and my colleagues at the table to take smartphones off so that we don't get interference. As you all know, those members who are using laptops are doing so to access materials for the board, and are not doing making travel plans or doing email. This is an official meeting of the Medical Board of California, and we will conduct it in as efficient and effective a manner as possible. We have a designated time on the agenda for public comment and ask for public comment on each agenda item. And I ask that we all be respectful of the need to conduct our business efficiently, and would ask our speakers, with the exception of the regulatory hearing, to limit comments to 3 minutes. There will be a red, yellow, and green light on the speaker's table. The board welcomes public comment on any item on the agenda, and in fact, it makes our deliberations much more effective when we hear from the public. We will end by between 12:15 and 12:30 today, this morning's session. We will have a break, and then we will go into closed session immediately after lunch, beginning at around 1 o'clock. We're going to take one item on the agenda out of order this morning. Agenda item 28, which is a report from the Midwifery Advisory Council, will be moved to follow the update on the prescribing task force to accommodate Ms. Sparavon's need to attend another meeting. And I want to call the meeting to order now and ask Ms. Toof to please call the roll.
Dr. Bishop?
Here.
Dr. Diego?
Here.
Dr. Gonadev? Dr. Kraus? Ms. Pines?
Here.
Dr. Lewis?
Present.
Mr. Louie?
Here.
Ms. Shipsky? Mr. Serrano-Sewell?
Present.
Ms. Wright?
Present.
Ms. Yaroslavsky?
Present.
Dr. Yip?
Here.
And Dr. Levine?
Here.
Thank you.
We have a quorum.
We do.
I'm going to start with public comments on items not on the agenda. And I have one slip, Alicia Cole from Consumer Union Safe Patient Project.
Oh, there we go.
Good morning.
Good morning. Good morning, members of the board. Thank you for having me here. My name is Alicia Cole, and I'm a survivor of multiple hospital-acquired infections and iatrogenic harm. And I'm here today on behalf of the Consumers Union Safe Patient Project. We are a nationwide campaign that is organizing patient safety advocates from across the state of California as the California Safe Patient Network. We believe that the medical board should make its investigatory process as transparent as possible to patients. Patients are at a great disadvantage currently when the medical board informs a complainant that the board believes their case does not constitute a violation, but fails to provide the expert consult report and the investigative file to the patient. Additionally, physicians are offered the opportunity to appeal the case to an outside entity, but patients are offered no such opportunity. We feel that the medical board should consider patients who have submitted complaints as a valued resource for important information. When the board feels that relevant information may be missing from a case file, the board should reach out to and consult with the patient complainant to determine whether the patient can share further information that would be helpful to fully understanding the case. This is not the status quo thus far. We urge the medical board to, prior to closing a case, notify the patient why the medical board feels their case does not constitute a violation. We ask that you offer the expert consult report and the investigative file to the patient and provide an opportunity for that patient to offer additional information to the medical board. If the patient still does not satisfy the medical board that it should pursue the case, then we ask that you offer the patient an opportunity to appeal to that outside entity. And we would like, consumers would like, to require the board to require a report from its staff regarding the criteria used for deciding to close a case. Also, the type of information that medical board expert consultants give the medical board when they recommend closing a case. We would like to know whether there are explanations that the medical consultants give to the medical board, which the medical board does not pass along to the complaining patient when a case is closed. Of utmost importance to patients is that during various stages of the complaint process, whether there are any differences in information or feedback a doctor and their lawyer are given by the medical board as opposed to the information or types of information that patients are given.
Ms. Cole, could you sum up?
Yes.
Your 3 minutes are up.
We would ask the board also how often physicians are late in submitting medical records, how often they're fined as allowed by law. And we would also like to know whether, since the medical board staffing levels have improved, the medical board has gone back to look at cases it turned away in 2011, and what kinds of cases you now consider low priority or no priority. Thank you.
Thank you very much for your comments. Are there any other comments from members of the public for items not on the agenda? If not, then we're going to proceed with agenda item 19, which is a public hearing on regulations. And we will open the regulatory hearing now. For the record, good morning. My name is Dr. Sharon Levine. I'm president of the Medical Board of California, and I will be presiding over this hearing. This is the time and place set by the Medical Board to conduct a public hearing on the proposed regulation to amend Section 1399.541 in Article 4 of Division 13.8 of Title 16 of the California Code of Regulations, as described in the notice published in the California Regulatory Notice Register and sent by mail to those on the board's mailing list. Current law permits a physician assistant to act as a first or second assistant in surgery under the supervision of an approved supervising physician. This rulemaking will permit a physician assistant to act as a first or second assistant in surgery without the personal presence of the supervising physician if the supervising physician is immediately available to the physician assistant. Immediately available means able to return to their patient without delay upon the request of the physician assistant, or to address any situation requiring the supervising physician services. For the record, today's date is February 7th, 2014, and this hearing is beginning at approximately 9:15 a.m. We ask that persons who wish to testify please fill out a speaker slip, which is available at the back of the room. The purpose of this hearing is to receive oral testimony concerning the regulatory proposal I've just described and as described in the notice. Regulations in the state of California must comply with 6 legal review standards, which are necessity. Is there a demonstrated evidence that there is a need for the regulation? Authority. Does the board have legislative authority to adopt the regulation? Consistency. Does the regulation conflict with other regulations or with statutes? Clarity. Can the regulation be easily understood by those affected? Non-duplication. Does the regulation duplicate other regulations or statutes? And reference. Which statute does the regulation implement, interpret, or make more specific? And testimony today should address only these 6 standards. Before we begin, I want to briefly describe the procedure that will follow today. The entire hearing will be tape recorded. Those persons testifying will not be sworn in or cross-examined. All recommendations and objections will be considered by the board members. Responses to all objections or recommendations will be included in the final statement of reason. The board will maintain a rulemaking file of this proposed regulatory action. Written comments for the regulation that we're hearing today should have been received by 5 p.m. on January 27th, 2014. The recording of this hearing, written testimony, and all written comments received by the deadlines as noticed will become part of the rulemaking file. For the record, 1 email and 2 letters were received and have been given to the board members. Copies of the 2 letters and the email are also on the back table for anyone who'd like to look at them. A completed copy of the rulemaking file will be available for review at the Office of the Medical Board in Sacramento. To ensure fairness and that everything is completely entered into the record, and to enable everyone to hear those who are giving testimony, we ask that those who are testifying please follow these procedures. Speak loudly and clearly and use the microphone. Identify yourself and who you represent. State your position, support or oppose at the beginning of your testimony. And we will, as I said before, testimony will be limited to 5 minutes during this regulatory hearing. And we would ask people to not repeat testimony already given. Any written comments you have with you today should be summarized orally, but not read. After legal counsel's opening statement, I will call on those persons who wish to testify. Ms. Webb, do you have any comments?
I think I want to address the email and the letters that we received. So I'll start with the email from Ruth A. Fox, MD. The email just seems to take issue with the whole idea that the physician assistant can perform procedures without the physical presence of a physician. And my recommendation is that we not accept this comment and make changes based on this comment. We received a letter from the California Hospital Association asking that the language be amended to be compliant with the definition from CMS, where immediately available means physically present, interruptible, and able to furnish assistance and direction throughout the performance of the procedure. I think that our definition of immediately available and interruptible is sufficient to describe what the relationship that needs to occur between the physician and the physician assistant, and I wouldn't recommend adding physically present.
Ms. Webb, could I just make a comment? Are we sure that they didn't mean uninterruptible rather than interruptible in that case? It would seem to be the spirit would be they would want the supervising physician to be uninterruptible at that point if they're needed. It seems interruptible is the wrong. There was a typo. Is what I'm getting at.
The physician needs to be interruptible, that you can say, I need you now, and the physician is not engaged in anything that
just
he or she
semantics.
can't
I was thinking
stop.
of it uninterruptible, that they can't be interrupted by anything else, that they can only
Right.
apply. So it's semantics. My apologies.
So just to clarify, it wasn't clear whether you said you recommend we should or should not.
Should not
Okay.
adopt that language. The next letter that we received is from the California Academy of Physician Assistants, and that was a letter in support.
Mr. Serranos.
Thank you. Ms. Webb, so you said we should consider including the physically present, is that right? I'm sorry, I'm going back to the California Hospital Association correspondence.
No, she clarified that what she said was should not.
Should not? Oh, I thought there was a yes on the physically present. I wonder what, we'll have the discussion later, Doctor? Okay, thank you. Thank you.
And that concludes the written comments that we received within the time period permitted for written comments.
So I have the following slips, starting with Greg Meny, from the California Physician Assistants Association? And could you, even though I read your name, could you state your name and who you represent, and again, begin with whether you support or oppose the proposed regulation?
My name is Greg Meny, and I represent CAPA, and I support the changes as for the amendment. I want to thank you for allowing me to speak today. I've received my PA degree and a Master's of Science degree in medical education from USC after serving as a corpsman in the U.S. Navy. I've been practicing for about 20 years as a PA and across multiple areas of medicine. Most of that's been focused in family medicine up until about 5 years ago when I was asked to join our surgical team. The reason I was asked to join this team was because of a decline in our general surgeon workforce. Our experience of general surgeon numbers declining is not uncommon, and they continue to decline, and gap in the capability to meet demands in surgery has been a topic of concern in the literature and by the American College of Surgeons. Over the last few years, PAs have tried to help out in that aspect, and we're not here to be surgeons or fill the surgeon's shoes in any means. We're here to assist. Our surgeons are feeling the increased demand of workload on them, both from now Affordable Care Acts that are creating more demand in the system, as well as the lack of people training in general surgery and the lack of numbers. General surgeons leaving practice and just the residencies not filling as well as they have in the past. So PAs over the years, at least certainly in the 20 years that I've practiced, have shown that they're very capable to work with all physicians in all settings across all spectrums of the healthcare system. And my supervising physician and I, we work very closely as a team. I often close when he's attending to different tasks, and he's always immediately available for me if I need him. So I realize that our goal here is not to solve the current sort of lack of general surgeons or the inability to fill the gaps in healthcare, but the clarification in this regulation really will help create a better availability for our supervising surgeons and a little more flexibility in their workday, and only serves to improve continuity, workflow, case capacity, and ultimately the level of patient care delivered. So to this endeavor, I ask the board for your support and consideration in adopting the proposed language changes, as it will allow for appropriate and customary supervision of the PA and the physician surgeon, as well as ensure that the regulations reflect really the current medical community standards and comply with the law. It would be very helpful for us to have that clear direction as far as our supervision and allow us to really serve our surgeons in a fashion that can really be beneficial to everybody in this system. So I want to thank you for letting me speak today, and I'm happy to take any questions. And I know I went through that fast. I talk fast when I'm nervous.
Thank you very much.
Thanks.
Teresa Anderson? Oh, sorry.
Good morning, Madam President and members. Thank you for the opportunity to comment this morning. I'm Teresa Anderson. I'm Public Policy Director with California Academy of Physician Assistants, and we do urge your support for adopting these regulations, the proposed language. We do feel that it will enhance patient safety by providing clarification to that.
Thank you very much. And Kim Kreifeld?
Good morning. My name is Kim Kreifeld, and I'm a practicing physician assistant in San Diego. I'm here today to strongly support the updated and clarifying changes to Section 1399.541 I-2 of Title 16 of the California Code of Regulations. I respectfully request that you adopt this language, which would end the differing interpretations amongst facilities concerning the personal presence of the supervising physician. I currently assist multiple physicians at different facilities in San Diego, and there are varying interpretations of the 2005 opinion of what within the line of sight or earshot means and what defines a surgical theater or area. By adopting the new language and clearly defining immediately available, this resolves the ambiguity while maintaining consumer safety. Once again, I would like to thank the members of the Medical Board for the opportunity to voice my strong support for amending Section 1399.541 I-2 and bringing our regulations in line with the current medical community standards. Thank you.
Thank you very much. Tina Manassian? Oh, sorry. Are there any other individuals wishing to testify who have not filled out a form? Okay. Since no one else wishes to speak, the hearing is closed, and now we have time for a discussion among the board members. Mr. Serrano-Sewell, did you have I think you had a question?
I did, and just, I don't, well, I wonder if there may be some benefit to providing some clarity around immediately available, and if not, then, you know, just spend a couple of minutes on it, Madam President, if that's all right. I mean,
Sure.
it is somewhat subjective, but perhaps that's okay, the word immediate.
Do you want to read? I'm going to ask Ms. Webb to read the language, actually, so
Thank you.
we can.
So I'll start from the beginning under subsection 2. A physician assistant may also act as first or second assistant in surgery under the supervision of a supervising physician. The physician assistant may so act without the personal presence of the supervising physician if the supervising physician is immediately available to the physician assistant. Immediately available means able to return to the patient without delay upon the request of the physician assistant or to address any situation requiring the supervising physician's services.
Thank you, Ms. Webb. I just wanted to, if there's no other comments, I think and I just looked at it, the without delay language is very instructive.
This cannot be a telephonic availability.
Okay,
Right.
yeah.
I do have another comment. I guess the "or" now, once you read it, bothers me because the physician assistant may say, "Can you please come?" But because the physician has the "or," they say, "No, just do X, Y, and Z," when really what should have happened is that the physician should have come back. What you just read, or address the situation requiring supervising physicians.
Read the sentence again.
Immediately available means able to return to the patient without delay upon the request of the physician assistant or to address any situation requiring the supervising physician's services.
So that's my concern in surgery. In surgery, that's my concern, that the physician may say, "You're going to be fine, don't worry about it," versus if it's like some other patient. But in surgery, that's my concern, that "or."
So an "and."
Or how about in order to?
I read it as upon the request of the physician assistant, or if the physician is aware that there's a problem without the physician assistant's request, that the physician returns.
Is there a way to make that language stronger? So that's why I was suggesting if you would just, in order to.
Well, I might argue that there are some situations where the PA doesn't require the physical presence. It's not a situation that's that severe. Simply, would you like to use Vicryl or Tycron to close this wound, where they don't absolutely have to be there, and it's just something, or which antibiotic would you like during surgery today? Those sort of things don't require the immediate presence, but certainly the immediate telephonic presence.
Availability.
Or maybe they're outside the room, but we've tackled this with the supervisory committee as well, and there's always going to be difficulties with trying to narrow this down and strengthen it. And the trouble is, you strengthen it more, you actually create more loopholes and more confusion. And it's one of those things where if something quacks like a duck and looks like a duck and has a bill and yellow feet, people kind of know what what it is. And so people generally will know what immediately available and what requires immediate availability. That's how we tackled it in the supervisory committee. Not perfect, certainly, but that was
So
what we were thinking.
if Ms. Webb and Ms. Staub's interpretation is that the "or" is to give the supervising surgeon the discretion to say, whatever the PA says, I'm coming in, which I'm not sure they actually need, but perhaps language that says, or at the discretion of the supervising surgeon, supervising physician to address.
I don't think that that's what it's getting at. I think this is saying you need to be close by because you need to be available to address this. The physician always has the discretion to come in. I think this is saying.
Right, they don't need that. So where, I'm sorry, where I was thinking is, it's like human nature and that the physician assistant may be requesting the physician to come in, and the physician may be using their discretion to say, you're going to be fine, whereas the physician assistant was actually asking for help. Can you come back? It happens, and the physician is using their not best judgment to say, no.
Can I ask a question?
My concern.
Are we allowed, can we create advisory notes? Like, is that something that can be added to this to be more clear? No, okay.
Like a signing message?
The question is from the legal perspective, we've heard the response. And from the medical perspective, we're hearing a different response. My concern is which response is going to be assumed in the situation.
I'm going to ask the question again, would putting an "and" in there solve the problem that Dr. Diego is raising without changing the intent of this?
I'm not sure that it's going to be helpful. I mean, it's the way this language is now framed. It would mean that the PA can request, and it trumps the supervising physician's decision. If the PA who's on the site says, I want the doctor to come back, that trumps what the doctor says, and no way you can take care of it.
Right.
The PA makes the decision. The PA is on site, and that should take precedent over what someone at a distance, hopefully very close by, would make. So I think the language is better without the "and."
I agree. I think the intent is clear. I think the "or" is acceptable.
Well,
suppose you took the word "or" out and just said "to address."
That's why I suggested in order to, the same thing.
Would that?
That, now I hear what you're saying, Barbara, yes.
See, that's why I suggested the in order to, but the
Yeah.
taking the or out is,
I think if we take the "or" out.
I think that solves your problem.
Okay.
Take it out.
Mr. Louis, does that?
Yeah, I think that would be even clearer.
Okay. Can we do that?
What we'll have to do is, because it is a change, your motion would be to direct staff to go back and modify the language. It would go out for a 15-day comment period. If there are no negative comments, then you would direct the executive director to move it forward through the legal process. I guess maybe at this point, so we kind of circumvent those negative comments, I was wondering if we have, when in public comment, if anybody has issues with that, we would like to hear them probably at this time.
You guys are okay? Dr. Yip?
Since sounds like it's going back to public comment again, right? So just for the sake of discussion, I'm probably the only surgeon in the room here. I'm a urologist. I do support the PA's work, but I do sense the uneasiness of the California Hospital Association, the word immediately available. I have no problem what we have right now, but I do like to hear the public comment in the future about how to reinforce that. I can see why the hospital should bring that up, because in the hospital, we do have problems sometimes to define that, to discipline doctor, to peer review doctors. I'm comfortable with language because right now, PAs do peer reviewed like surgeon. We have interdisciplinary committee, etc. With credential committee looking into that. I actually like to see in the future the PA curriculum more catered to certain specific extra training if the go to surgical field, orthopedic field, ICU care, etc. That's not the scope of this language. But I have no problem with language, but I do see the concern of the hospital association. Maybe public comment can bring back, so we can refine more of that.
Maybe we can ask the PA committee to take a look at the issue of the curriculum, the training.
Yeah, we talked yesterday with Dr. Bishop.
Okay.
Sure. Let me address that, then make a little bit of a statement that I just kind of scribbled down here. But I just want to bring up something that's relevant to this, and we all believe, I think, that the PAs are a good resource in California as physician extenders. But I just want this board to know something we're struggling with on the PA board is that the PA national organization is now forcing all PA programs to become a master's level program, which will result in closure of many programs in California. And the PA board finds this very concerning, and we're trying to address that in some fashion because it will close in these programs and diminish the number of PAs that we're able to provide for the citizens of California for their valuable resource. But I also just wanted to mention, I know that there's concerns with respect to the abuse of this regulation by physicians and PAs, with PAs doing the whole procedure while the physician sits in the lounge doing their stock exchanges. And I think that the concern can certainly apply to any health extender, nurse practitioners, CRNAs, and I work with CRNAs every day as an anesthesiologist. So I realize these concerns exist. And there's always going to be rogue providers who will try to take advantage of something. But I think in this case, the relationship between the PAs and MDs is well established and clear, and this has been this way for many years. They function as a physician extender. My impression from working with them in the OR and also on the PA committee is they're not trying to expand their scope of practice. They just simply want to have a codification of what's already happening. And I believe they just feel that this is necessary to continue what they're doing to provide the help to the physician. So I don't believe the intent is wrong.
Thank you very much, Dr. Bishop. So I think we're ready for a motion. Kim, would you restate the motion somebody should make?
The motion would be to approve the language with the deletion of the word "or" and direct staff to take this back and put it forward for a 15-day comment period. If there are no negative comments, to move that forward through the regulatory process.
So moved.
Second.
You have a motion?
We have
And to give authorization to the executive director to approve that and send it to the Office of Administrative Law.
May I restate the motion, because just in case there's any non-substantive changes, we have to have authority to make those. I'm not anticipating it, but to make sure we're covered. So I'll say I'm suggesting a motion that you direct staff to take all steps necessary to complete the rulemaking process, including preparing the modified text with the deletion of the word "or" for an additional 15-day comment period. If after the 15-day public comment period no adverse comments are received, authorize the executive director to make any non-substantive changes to the proposed regulations before completing the rulemaking process, and adopt California Code of Regulations, Title 16, Division 13.8, Article 4, Section 1399.541. May I have that motion?
So moved.
Second.
Any further comment from board members? Members of the public? Seeing none, all in favor?
Aye.
Aye. Any opposed? Any abstentions? Thank you very much. Okay, we will now move on to our next agenda item, item 20, update on the PA board. Dr. Bishop. Dr. Bishop.
Pardon me, ma'am, I'm sorry.
Update on the PA board.
Oh, yes, I'm sorry. I hadn't moved on yet. At the last PA board meeting, we had a re-election of Robert Sachs as the president for 2014, and Charles Alexander was elected vice president for 2014. We discussed mandatory reporting requirements for physician's assistants. There are several types of professional reporting requirements for PAs. the employer, such as 800 series, hospital suspensions, discipline, employee, self-reporting, convictions, etc., reporting regarding certain medical conditions of patients, such as abuse or diseases. The board requested that staff develop a fact sheet to include PA mandatory reporting requirements and update the board's website to show this information. Current voluntary exam about PA laws and regulations available on the board's website. The current voluntary online exam contains 10 questions. These questions have not changed since the exam was first placed on the website several years ago. The DCA Office of Professional Examination Services has identified approximately 20 additional questions. We are scheduled for online applications in April 2014 and online renewals for August 2014. The bulk of the meeting was spent with review and updating the board's strategic plan. The board's strategic plan was last updated in November 2009. The board is now in the process of reviewing and updating their plan. The board has developed new objectives for the plan. A draft of the plan will be presented to the board at the February 2014 meeting. At this meeting, the board will also review and possibly update the current vision, mission, and values. The next PA board meeting is scheduled for February 24th, 2014. And as I already have said, I think the most important thing that we're looking at is with respect to maintaining and even increasing the number of PAs available to us in California. Thank you. Any questions?
Any questions from board members? Any comments from members of the public? All right, seeing none, thank you so much, Dr. Bishop. We'll move on to agenda item 21, update from the Department of Consumer Affairs. Christine Lally, welcome.
Good morning, President Levine and members. Christine Lally, Deputy Director for Board and Bureau Relations with the California Department of Consumer Affairs. Always a pleasure to be with you. Just wanted to give you a brief update on the 3 projects that we have underway. As I'm sure you all know, we are working very closely with your executive officer and the department on the implementation, as you heard yesterday, of SB 304 and the transition of the investigators, as well as the BRIE system and correcting some of the defects that we've discovered in the system, including the reports that are run. And we're also working closely with Kim on the CURE system implementation, which is the California Prescription Monitoring Program. So those are underway, and we are in contact with Kim and staff pretty much daily at this point. Very close working relationship. And, you know, I think it goes without saying that all 3 projects have their challenges, but in working together and the close relationships we have and the good flow of communication, I think, you know, we're addressing them. In some areas, I wish we could address them a little faster, and we concede that, but we're working on it. And specifically on behalf of Director Brown, she asked me to convey to the board today her appreciation to Kim Kirkmeyer for her extreme dedication to all 3 projects and her great leadership on all 3, especially Kim and Ms. Threadgill's dedication on SB 304 and making that transition as smooth as possible. It really is a pleasure to work with the staff of the medical board and just the free flowing of information and willingness to share with the department. And I think my colleague, Mr. Gomez, would agree that it really has been wonderful to learn from Kim and Ms. Threadgill and glean their great experience. So our appreciation to you, Kim. Thank you. Also, I wanted to welcome Judge Louie to the board and congratulations on your recent appointment. And just remind Judge Louie, since you are the newest member to the board and some of the other board members that were appointed last fall, I'm going to make my pitch again for required training. We have our board member orientation training coming up April 2nd, which I think is a Wednesday in Sacramento. And board members are required to complete that training within 1 year of their appointment. So if there's other folks on the board that haven't gotten to that yet, you have your first opportunity of the year coming up here April 2nd in Sacramento. Also a housekeeping item in April 1st, to remind board members that you do have to file an annual Form 700 statement, and those are due on April 1st, and we want to make sure that all board members are in compliance. So the department will be following up with you shortly to give you some friendly reminders. But again, thank you to board staff for just working so great with the department. It really is helpful in getting these big projects implemented. So thank you.
Thank you very much. And I think on behalf of Kim, we all recognize the work that's gone on and appreciate the efforts of Kim and the entire executive team.
Agreed.
As well as your help. We really appreciate your willingness to meet with us and help us through those issues.
Thank you.
Can I ask,
sure.
How, I'm sitting here thinking about Breeze and Cures, two major IT implementations. How long do you anticipate the design phase? That is a DOJ effort?
That is their project, and right now we're in the FSR phase, so that's the feasibility study report. So basically, that's your report to put forward to the California Department of Technology saying, here's what this IT project looks like, this is our timelines, this is the business process that we're trying to accomplish. And so we're working with DOJ and the member boards to get that approved.
So do both these projects funnel into the same IT department, I guess is my question.
No, not exactly, no.
Okay.
Short answer, no.
Although it is something that, because of the legislation and the way it was written, it actually says that we have to try to streamline the process of it when you apply to the board or when you renew your license, also be able to funnel that into the CARES system somehow. So at one point, we're going to have to look at that.
Look at an interface.
And some kind of interface or something
systems.
between them, yeah.
That's, later down the road, long road.
Great, and I know there's been at least one interested parties meeting about the requirements for the system.
Yeah, we've had several.
Okay, great. Any board members have questions of Ms. Lally? Any comments from members of the public? And I want to thank you very much for coming to these meetings.
Always, wouldn't miss it. Yeah.
Great.
Thank you.
It's not the food, it's the company. Terrific. Thank you so much. Moving on to agenda item 22, Ms. Harold, report from the activities of the Board of Pharmacy.
Good morning, and thank you for this opportunity to address your board. It's always a pleasure. Ms. Kirkmeyer came to our meeting last week, and we gave her a few minutes, and so I'll be brief because I know you've got a very full agenda this morning. Just to follow up on cures, we have our prescription drug abuse task force meeting the day before you're going to have your next meeting. So I think I have a couple members that are coming to your meeting because we are very interested in still maintaining the momentum that we have in this area. I did a presentation. We do these day-long trainings with pharmacists so they can earn CE, learn about drug diversion, learn about prescription drug abuse, learn how to protect your pharmacy so that you don't have robberies or thefts or whatever in order to help curtail the amount of drug diversion that's out there. We did it in Orange County, and they have a program running with the community where one of the high schools there, this is how alarming this prescription drug abuse is. The 2008 graduating class from this high school, it's a public high school, but it's in a very affluent area. 744 kids graduated, 11 of them have died so far in 2008 from prescription drug overdoses, 11 out of that class. We have a real problem here with the kids getting addicted, and just as the actor in New York did, you start with the prescription drugs, you end up on heroin. We need to continue to do our efforts here. We're not doing enough, and we're losing a whole generation that are coming up and becoming, unfortunately, addicted and ending up on heroin. And as we did presentations the last couple of weeks with the DEA to educate people. And as they will say, when you're dealing with a heroin dealer, you're dealing with a whole different quality of criminal than you are with a prescription drug pusher. And so again, then there's all kinds of side effects related to crime. So it's a scary world out there for some of our kids, and we need to do something about it as healthcare providers. Nonetheless, It looks like we will be working with you very soon on implementation of Senate Bill 493, which has specific tasks that pharmacists can do once the Board of Pharmacy and the Medical Board approve protocols. Specifically, we've got one for hormonal contraception. We have one for nicotine replacement nicotine replacement products. So we believe I initially had hoped to have some draft protocol to this board before your April meeting, your next meeting. I don't think that's going to happen. The target then will be July because we have to also run it through our meeting. You also have representatives that can help us develop the protocol. We're working with community groups, and our first meeting on this is actually next Wednesday. So we will work with Ms. Kirkmeyer to find how the two boards are going to work outside of meetings so that you have input at the development stage and not at the final stage with, okay, you're done, this is okay or this isn't. So, and the degree of involvement is up to you, how much you want to participate. But we're just starting that process. There's also components for immunizations. There's also travel meds all in there. So there's a lot going on. We're a little busy on that one. We are talking about the CURE system during our prescription drug abuse committee, and the reason we're talking about cures is that we have the same mandate you do, that by January 1, 2016, all of our licensees, in our case all of our pharmacists, are signed up with cures. That is 2 years from today. It isn't going to happen unless we do something. So what we're doing is we're going to try to work with the Department of Justice a little bit on an interim measure to try to help us get our pharmacists signed up so that they can access the data from the pharmacy or wherever it is they're working. In the case of pharmacists, every pharmacy has to have a pharmacist in charge that oversees the operation. We're going to start and target at that level, we think, and get them enrolled and put in the system so they can access reports and then hope that it'll feed back to all pharmacists eventually. I have expressed my reservations already, though, with Senator Desaulniers that I don't think we're going to be able to reach the January 1, 2016 date. So, but we're working towards it. Part of it is we're transitioning to that new computer system, Breeze, as well as, and that affects renewals, as well as the CURE system itself. And the goal is to ultimately have some kind of crossover. Oops, sorry. Okay. In case you didn't know, because I was caught by surprise, March 2014 is Prescription Drug Abuse Awareness Month. Senator Desaulniers passed a Senate concurrent resolution last year that just encourages us to go out and do something to help educate the public, which I know we all want to do. And on drug safety, in the area of drug safety, which is where our boards have an overlap with your practitioners, we're working to implement SB 294, which deals with sterile compounding. This is where a pharmacy does high-risk compounding, where it's an inhalation product, it's an eye administration product, or it's an injectable. We now require that they be specifically licensed with us, subject to an unannounced inspection. If you're buying outside California or in California, we will be inspecting these facilities, and this is in part by gap caused in terms of the way the nation as a whole, and specifically the FDA, regulates this area, and the expertise that some of these large sterile compounding pharmacies develop, where if we stop them, it drives it down to less qualified practitioners that will attempt to fill the void, which creates even a greater public health risk. So we're moving in that direction. The actual implementation date is July 1, 2014, but we're doing the inspections of hospitals right now. So those of you that work in a hospital environment, we're already coming in unannounced, and surprise, we're here. So we're checking every place that you are doing sterile compounding within the facility. They will have to be licensed with us. Federally, we now have a new track and trace law, which is going to track prescription drugs as they move through the supply chain. It preempts our legislation that we had on the books. So we basically have been credited with securing national legislation. Frankly, it was the one thing the supply chain could agree on, get rid of those California implementation dates. They now have 10 years to comply, at the earliest 10 years to comply with what we had on the books that would have been in effect by July 2017. And the FDA is developing a new outsourcing structure. It's called an outsourcing facility for large compounders that are neither manufacturers nor pharmacies. And that's a 3-year project, and then they'll have to do permanent legislation behind it. But they've kind of got it out there as a trial for 3 years, so we'll see where it ends up. So, and lastly, we have approved a pilot study with UCSD to experiment with a method of drug delivery to patients where they can pick up their meds from a vending-like machine. After they've been counseled, they can go to the machine, get the meds, so that in the event that, and this is available in the employee's workplace. In this case, it's at the Sharp Hospital Main Hospital in San Diego. So we're just at the front end. They're finishing the protocol for the research study, and we believe the board will approve it at the next meeting. So that concludes my report. It's a pleasure to be here. Any questions?
Questions from board? Dr. Yip.
What is the current situation for like workers' comp clinic or doctor's office dispensing medication? Do they need to be licensed with the pharmacy?
Not yet. We have no plans to do that. Physicians under Business and Professions Code Section 4170 have the ability to dispense to their own patients. They cannot operate a drugstore, but your own patients you can dispense from your office.
The reason I asked, like the pharmacy, if they prescribe bottle medicine, there's rules that says you have to certain element on it, right? Instruction, etc. But I see some patient coming with a bottle, just say Cipro twice a day.
Why not? There's a problem with that, and let us know. Have either the patient file a complaint or someone in your office file a complaint with us. We'll come out and do that. The labeling on a prescription container is essential for the patient to understand how to take the meds. That's insufficient labeling. It's a violation of law.
It's a violation of current law. Physician who operates as if he or she is a pharmacist needs to ensure that the labeling, right?
Yeah, oh yeah.
And lot numbers and things like that. I mean, there are documentation requirements.
I misunderstood. I thought you were saying that you were seeing it being dispensed by a pharmacy with insufficient labeling.
No.
I'm saying that since physicians dispensing medicine, they may not be under the same supervision like the pharmacy under you. And how do we fill the gap?
That's your jurisdiction, but we will work with you. And one of the things, we just got a public information officer. And one of the things Ms. Kirkmeyer and I have wanted to do is have reciprocal articles developed where we write some for physician audiences, essentially. Prescription labeling would be one of them. And then some of the physician issues with pharmacy would come in our newsletter so that we can better train our licensees on how to work better together, which is, again, part of our collaboration.
Dr. D.
I was going to say, but just to clarify for Dr. Yip's sake, the law is you have to write the label just like the pharmacy does.
Yes.
And you have to keep records of
Yep.
it. That's
Right.
why it's so hard to have samples, because you have to do that whole thing. So
And
we
actually,
definitely have to educate our physicians.
yeah. And actually, I believe as of with SB 809, they have to report into the CARES system too. I think. I'm not
Actually,
sure
it's
if
been a requirement for years. If you dispense from your office controlled substances, they have to be
They
reported.
have to go in.
If it's
yeah.
more than a 3-day supply.
That's probably something in our upcoming newsletters.
So I have a question. March is the Drug Information Month. Is there any kind of activities going on as far as drug take-backs or any kind of information for consumers that you can share an email blast or something that, in addition to it's a month of whatever?
Well, Senator Desaulnier picked the wrong month. He should have used April if he wants to mesh with the DEA. The DEA's drug take-back is April 26th, whatever the last Saturday is in the month. So
the promotion could start in March, or could start...
And encourage it, right.
Okay.
And the destruction piece is an important part.
So I'm just hoping that there's some shared opportunities
So
for
I think,
some...
Yeah, and I think the question is, do you have anything actually planned
Right.
that we can...
We have a board member that's offered us PSA radio time, so we are going to take advantage of that. So right as we speak, I hope, I have a couple 30-second PSAs that are being written.
Great.
And we had actually talked at Ms. Harold's meeting about this whole thing. We had actually met with our PIO before that, talking about we'd like to do 2 PSAs, one targeting physicians on the whole overprescribing issue, and one targeting the public, including the whole drug take-back, what to do with your medications, and just the whole issue of you need to be careful when you're prescribed pain medication. So we talked about working together. I kind of hit up one of their board members, the one that's willing to do this now, so.
I didn't know that.
Shared resource.
Well, hey, use your resources. We don't have enough of them.
Any other questions from members of the board? Members of the, any comments or questions from members of the public related to Ms. Harold's presentation? Thank you very much.
Thank you.
Moving on to agenda item 23, update on the prescribing task force. Dr. Bishop.
There's nothing that's happened substantially that we can show since the last meeting. However, we have our next meeting coming up on February 19th in Sacramento. And due to the incredible efforts of Ms. Kirchmeier, we have both national and international experts who have agreed to attend. And we're going to be at that point in time looking into changing the prescribing practice guidelines for our physicians in California. And we've had discussions between myself, Ms. Yaroslavsky, and Ms. Kirchmeier, which have been productive, and we're looking forward to a productive meeting. If there's anything I've forgotten, please add to that.
And that is February 19th from 10 to 4 at DCA headquarters.
Correct.
And any and all board members are encouraged to attend. Great, thank you so much. Any questions for Dr. Bishop? Any questions from members of the public? And we will have the, oh, sorry, Dr. Yip.
I have a personal comment to Dr. Bishop the other day. I just want to show the board members that to clarify certain situation that physicians prescribe pain medication, under what circumstances they're required to do like a pain contract management type of thing. So
perhaps our legal folks can clarify. Dr. Yip had the question because we have seen in some of our disciplinary proceedings statements that so-and-so had prescribed narcotics without a pain contract, and under what circumstances is a pain contract required for any dispensation of Schedule IIs or not? That was what he's asking. We may not come with the answer today, but I'm just clarifying that was his question to me, which I couldn't answer.
Just a point of clarification, Dr. Yip, I apologize stepping on legal before you speak. Are you asking for this to start to have a discussion because that's what you want to see happen? Because it's currently not the law.
Well, that's the thing. I think there's some cases that I read, that's what it mentioned, that the physician, quote-unquote, violated.
It's not mandated. So I'm asking, are you asking for us to take a look at starting to have a law change?
No, I'm asking to clarify that.
Clarification.
Under what circumstances, and that will be part of the pain management guidelines,
Yeah.
under what circumstances.
Because some of the members, I'm sure you read the cases, at least one case mentioned that, oh, the physician did not have a pain management contract with the patient and signed as a violation, so.
Right.
I think these are, it's a case-specific evaluation where our medical experts look at the totality of the circumstances and determine whether there was a breach. There's no written standard of care regarding it.
Thank you.
And as part of the guidelines.
Exactly right. So it's a great question we'll address.
There will be information about when a contract is appropriate. Great. Again, any questions from members of the public? Okay, we'll move on now to Ms. Sparavan.
Where is she?
Carrie Sparavan, I know I saw her here. Oh, sorry. Welcome. This is a report on the Midwifery Task Force. We're taking this out of order so you can get to Santa Rosa.
I really appreciate you taking me out of order. I've got another important board meeting to attend in Santa Rosa this afternoon. My name is Carrie Sparavan. I'm chair of the Midwifery Advisory Council to the Medical Board. Our last MAC meeting was on December 5th, 2013. We discussed the impending changes brought about by AB 1308. There was an interested parties meeting that same day, and after that meeting, it was clear that the two issues that are going to require the board to create regulations around both creating a list of conditions that will require a physician referral from a licensed midwife and the creation of a form for reporting the hospital transfers were likely to be agreed upon by the interested parties. Since that meeting, the working group for the creation of the reporting form is making good headway and should have something to submit to staff by the end of this month. The work group for the creation of the list of conditions for referral has agreed to use the list that's already contained in the standard of care with the exception of VBACs, which is still in negotiation between the parties, and I'm really hopeful that they will all come to some agreement before the next interested parties meeting. Karen Ehrlich gave us a report of the last 5 years of statistics for licensed midwives, basically from the inception of us reporting. And the statistics have essentially remained the same. There's been a fairly significant rise in the number of out-of-hospital deliveries that licensed midwives are attending. But even with that rise, our statistics are staying in line. Of really significant note is that the cesarean section rate in this group of women has remained significantly less than 10%, with the last 2 years 7.1 and 7% respectively, which is significantly less than the national average of over 30%. Faith Gibson and Dr. James Byrne agreed to work on creating an information packet that can be presented to new board members around who licensed midwives are and what we do and how you can best support us. So that's the end of my report. I still need some agenda items approved for our March meeting. We need an update, probably coming from the California Association of Midwives, on how midwives are doing with their ability to obtain drugs and devices as dictated now under AB 1308. We're expecting a report from staff on the issue of midwife assistance and what is going to need to happen to really, finalize what can happen there legally. There are several issues to be addressed around the reporting statistics. We expect an update from OSHPD on how that system's working. We will probably set a task force to work on possibly changing the data set as dictated by AB 1308 to come more in line with what's being collected nationally by the Midwives Alliance in North America. And Karen Ehrlich is going to give us a further update on the statistics from the last 5 years. There is going to be a staff report on how the challenge mechanism will look going forward after 2015. An update on moving forward with regulatory changes, how that process is proceeding. And I'd like a staff report on how we can proceed with accepting certified nurse midwifery schools as part of the schools that are accepted for midwifery licensure, with the removal of physician supervision as a requirement for licensed midwives. Certified nurse midwives are now asking what they can do to be licensed as licensed midwives because their statute still requires physician supervision. So I'd like staff to kind of look into what that would look like and how we might create a kind of a streamlined way for those CNM schools to be accepted. And that's all I have. Thank you very much.
Any questions for Ms. Baravan from board members? Ms. Yaroslavsky.
My understanding is that she needs an approval
of the agenda items, correct.
So I was going to offer to move that forward as a motion.
Go right ahead.
So be it.
Have a second. Any further questions, discussion? Any questions or comments from members of the public? Seeing none, all in favor of the moving approval of the agenda, please say aye.
Aye.
Aye. Any noes? Any abstentions? Thank you very much, and thank you, Ms. Sparrow.
Thank you so much for accommodating my schedule.
You're very welcome. So our next agenda item is a presentation on the National Association of Optometrists and Opticians versus Harris litigation. This is, in here today to provide the presentation is Mr. Alfredo Terrazos, Senior Assistant Attorney General in the licensing section of the Attorney General's office, and Ms. Schneider, Deputy Attorney General in the licensing section. And for our new board members, the Medical Board of California has oversight over registered dispensing opticians. And this is to bring us up to date on the result of litigation that's gone on for quite a while, actually.
Just a note for the record that I represented the lens crafter affiliation to the Supreme Court of California, and I just want to note that for the record.
Okay. Thank you so much.
Thank you, Judge Liu. The invitation that you gave us for this opportunity is very welcome. Thank you, Dr. Levine. Thank you, Ms. Kirschmeyer. The licensing litigation section, of which my colleague, Supervising Deputy Attorney General Linda Schneider and I are part of, are the section that represents a lot of the agencies within the Department of Consumer Affairs. Our counterpart, Health Quality Enforcement section, represents you. But, for example, we represent from accountancy all the way to veterinary medicine. Ms. Harold is one of our client agencies. Board of Optometry, Dentistry, Veterinary Medicine, just a whole slew, including both nursing boards. And just as a side issue, there's a hearing that starts today in Oakland with regard to certified nurse midwives on the issue that you just heard with regard to physician supervision. That's scheduled to go for, I think, all of next week as well. So you might be seeing something about that in the newspaper. In any event, what we're trying to do here is give you an update on litigation that we've been involved with for quite some time that does impact one of your programs, as Dr. Levine indicated, which is the Registered Dispensing Opticians Program. It's involved with litigation that actually challenged the regulatory schemata dealing with the allowable and prohibited relationships between RDOs, optometrists, and in some instances even manufacturers. And the core issue, just so you know, happens to be whether or not there is any element of commercial control over the clinical judgment of the optometrist, since it's the optometrist who writes the prescription, which is the pathway for the glasses that we all wear. And just so you know, the difference is that we perceive the glasses to be a medical device and not a fashion device, you know, like a tie might be. And that's the way we interpret the laws in force for the Board of Optometry and that impact your RDO program. So we've prepared, Ms. Schneider is going to present a history of the litigation to help you understand where we are. You should also know that we are actively engaged with most, if not all, of the major stakeholder players in the industry, trying to make sure that we all understand their business operation models and reviewing those for compliance or non-compliance with California's regulatory scheme. Okay?
Thank you very much. It's a pleasure to have the opportunity to address the board this morning. We're here, as Alfredo mentioned, to provide an update concerning litigation that for the past several years has affected the board's Registered Dispensing Optician Program, which we sometimes refer to as the RDO program. The case concerned the constitutionality of Business and Professions Code statutes and regulations known as commercial practice restrictions. I was initially assigned as part of a team to defend the state in this action, later became the supervisor of the case, and ultimately brought it to conclusion in the United States Supreme Court. Let me identify for you the parties that were involved. National Association of Optometrists and Opticians is the National Trade Association for chain store retailers of optical goods. LensCrafters, the second plaintiff in the case, has approximately 110 stores dispensing eyewear in California, and each store is registered as an RDO, or Registered Dispensing Optician. Eye Care Centers of America is a national retailer as well. However, they don't do business in California. Their allegation in the lawsuit was that they were unable to enter the market in California because of California's restrictive regulatory scheme. The defendants in the case were the Attorney General, Kamala Harris, and the Director of the Department of Consumer Affairs, Denise Brown. I'll be discussing today primarily two legal actions. One was People versus Cole. In this case, the licensing litigation section took an enforcement action against Cole National and its subsidiary companies Pearl Vision and Pearl Vision Care, which is a California Knox-Keene plan. This was litigated in state court in San Diego. In the second case, National Association of Optometrists and Opticians, which we call NAOO, we defended a federal action which the optical industry brought against the state seeking to enjoin the statutes and seeking to hold them unconstitutional. Before going deeper into those cases, I wanted to give you a bit of a historical recap of eye care in California. Currently, there are 3 O's in the vision care field: optometrists, ophthalmologists, and opticians, but it wasn't always so. In the 18th century, it was only 2 O's, oculists, which became ophthalmologists, and opticians who created glasses, crafted glasses. Optometrists evolved as a subset of opticians, and in 1903 became regulated in California. The Optometry Board was created, and many other states eventually also created optometry laws. And many of them included commercial practice restrictions, such as the ones we'll be discussing here today. They were an early part of the licensing scheme and were intended to prohibit relationships that give retailers an avenue to control doctors. As the profession of optometry was developing, retailers were accustomed to using optometrists to sell eyewear in their stores. But optometry was struggling to become a real medical profession, and optometrists did not want to be just a tool for retailers to sell goods. Consumers were beginning to rely upon optometrists as doctors too, and it was becoming more important that optometrists, with their ethical considerations and duties, were considered to be a real profession. So the goals of the statutes were to prevent control by retailers over professional medical judgment of doctors, to assure that prescriptions for eyewear were written based upon real patient need, rather than just for commercial retailers to earn profits, to prevent quickie eye exams, because more eye exams equal more prescriptions equal more sales of eyewear, and to promote the professionalism of optometry as a real profession. California statutes restrict commercial practice in 3 ways. First, by restricting relationships between optometrists and physicians with registered dispensing opticians. Second, geographically, physical separation of optometrists and opticians from registered dispensing opticians. In other words, so they're not all on the same premises. And lastly, in advertising, registered dispensing opticians are not allowed to advertise the services of optometrists or ophthalmologists or to offer eye exams. So early legislation in this field, in 1937, Section 3109 was enacted by the legislature. And this section does not allow anybody other than an optometrist to employ an optometrist. So it was made clear that registered dispensing opticians could not employ optometrists. And the theme of preventing control of doctors by non-licensees was very apparent in the early statutory scheme. However, however, the optometry board had established regulations early on as it became a profession, as optometry became a profession, and allowed one exception, and that is that if an optometrist wants to practice in a commercial setting, the practice must be owned by the optometrist and in every phase be under his exclusive control. This regulation became the Board of Optometry Regulation 1514, which still exists today, and permits optometrists to work in retail settings, but still does not allow optometrists to be on the premises of a registered dispensing optician. In 1939, opticians became regulated by the state. Business and Professions Code Section 2556 was enacted, and this provision is applicable to optical stores and individual opticians. It provides that it is unlawful for RDOs to advertise the furnishing or to furnish the services of an optometrist or a physician and surgeon, to directly or indirectly employ an optometrist or a physician, or to maintain on or near the premises used for optical dispensing an optometrist or physician and surgeon. In 1949, the legislature also enacted Sections 650 and 654 together in a single bill. Section 650 prohibits unearned Section 650 prohibits unearned consideration for referrals, so no kickbacks or rebates. And Section 654 addressed relationships between RDOs and physicians. If any referrals were made between them, that would be illegal, and no profit sharing of any type was allowed. The courts in the mid-50s interpreted some of these commercial practice restrictions. First, in the United States Supreme Court, Williamson versus Lee Optical was addressed. The United States Supreme Court upheld the Oklahoma statute that prohibited an optometrist from being on the dispensing premises of a retailer. This was a statute similar to 2556 here in California. The court upheld the statute and said, the statute is an attempt to free the profession to as great an extent as possible from all taints of commercialism. And then here in California, a year later, in Drucker versus State Board of Medical Examiners, this very board, a California Court of Appeal rejected discipline against an RDO for leasing space to an optometrist as a violation of Section 2556. In this case, the facts did not show any employment or other relationship between the RDO and the optometrist other than landlord-tenant, which was not prohibited by the statute. But the legislature would later amend or enact a new statute to prevent such landlord-tenant relationships. But the court noted in its decision the basic aim of all statutes enacted with reference to this subject matter is the elimination of the chance of dominion of the professional decisions of the practitioner by commercial interests. So again, preventing control of optometrists or physicians by RDOs was an important consideration. Then in 1969, the legislature enacted Section 655. This section does, in fact, prohibit landlord-tenant relationships between RDOs and optometrists. And it also prohibits other relationships, such as profit sharing, membership, and things of that nature. But as the statute was originally enacted, it also required that there be a referral arrangement between optometrists and opticians to show a violation. That was later to be amended. The 1970s was a busy decade in the vision care industry. In 1973, Richard Nixon signed into law the Federal HMO Act. This was a huge change in the way medicine is delivered in the entire country, as I'm sure you all know. Before the HMO Act was enacted, for-profit lay companies or corporations were not allowed to participate in the healthcare delivery system, and they could not profit from it. This activity was restricted to licensed professionals only. But the HMO Act changed that and allowed lay companies to come into the healthcare delivery system. 2 years later, in 1975, California enacted its HMO law, which is the Knox-Keene Healthcare Service Plan Act of 1975. It was similar to the federal HMO Act. And under the Knox-Keene Act, any person could own a Knox-Keene plan, and the person is broadly defined, so it could be anybody, including a lay corporation for profit. For-profit companies could in fact participate and profit from their activities, and Knox-Keene plans could also either directly or indirectly employ or contract with medical professionals to provide their services. Of course, the providers had to be licensed according to their own licensing laws. Then also, that same year, the FTC was given expanded authority to prevent unfair business practices affecting commerce. And one of the first things that the FTC did was to investigate the vision care market. They did a rulemaking proceeding to establish what has become known as the prescription release rule. That was in Eyeglasses 1. The prescription release rule requires a prescriber of eyewear to give the prescription to the customer. And this allowed the people to be able to take that prescription, take it to an RDO store, an optical store, to have it filled if they wished. So that was a good, a tremendous benefit to the RDOs in California when that rulemaking proceeding went into effect. Then the FTC also began investigating optometry. In 1977 and 78, the FTC did undercover investigations of the vision care market. They wanted to determine whether commercial practice restrictions were actually harmful to consumers. So undercover investigations were done in 15 states where laws were different in each of the states. They wanted to compare markets where advertising of eyewear and professional services such as optometrist services were allowed with states that did not allow such advertising. And also to compare where chain stores were permitted to have optometrists on their premises and states that did not allow that. So they were basically comparing commercial practice versus private practice. But as the undercover investigations were ongoing, in 1977, the United States Supreme Court decided Bates versus State of Arizona, and this said that...
I'm going to interrupt you just for a second. We've got about 10 more minutes.
Yeah, we need to...
Okay, thank you.
So I'm going to ask you to move through the slide so we can... I don't want to miss the punchline on this.
Yeah, the case has been disposed. I mean, we have the disposition of the case, so...
So where we stand in terms of...
Get to that and the holding, and that would be really helpful.
Thank you. I'll move forward then. Section 655 was amended in 1975 to remove the referral requirement. In the 80s, okay, this is when things start to heat up. The Pearle Vision begins franchising to optometrists. So they now have optometrists in their store, open and notoriously. But the California Association of Dispensing Opticians took action against Pearle Vision as an unfair business practice because they had the doctors in the store. The trial court issued an injunction stopping Pearl Vision and held that 655 was to be broadly interpreted. Then next, because Pearl Vision had lost and could no longer franchise to optometrists, they sponsored AB 1217 to try to change the laws, trying to get rid of Section 655 and 2556. They failed in that effort. But then they developed a new way of doing business to have optometrists in their stores under Knox-Keene. And in 1986, both Pearl Vision and LensCrafters established this kind of a program where they established a Knox-Keene plan, the HMO in California, in order to give a patina of legality to their having doctors in the store. They had contracts with Pearl Vision to provide eyewear plans to members. They employed optometrists as by the plan and did subleases between the opticians and the optometrists to have them in the stores. The Department of Corporations was the regulatory agency at that time and approved these plans. Later, it was to become the Department of Managed Healthcare. Then the Board of Optometry sued the FTC because the FTC had enacted rules and regulations saying that the states had to remove their commercial practice restrictions. In the case, the appellate court in the District of Columbia invalidated those rules because the FTC had no authority to enact them. Then, in 2002, in People versus Cole National, the Attorney General brought suit against Pearl Vision and its parent company, Cole National. The allegations were for unfair business practices and misleading advertising based upon violations of 655, 2556, and 3109 because of their business model where they were using the Knox-Keene plan to have optometrists in their stores. But then the optical industry did strike back. The very same year, in June 2002, the case of NAOO was filed not by Pearl Vision but by LensCrafters. LensCrafters sought to abrogate the statutes, the commercial practice restrictions, under theories of unconstitutionality under the Dormant Commerce Clause, Equal Protection Clause, Due Process Clause, and First Amendment. Ultimately, only the Dormant Commerce Clause claim remained. But at the same time, back in state court, in July 2002, in People versus Cole, a preliminary injunction was issued on advertising. So the trial court said they could not advertise the services of the optometrists unless they used a disclaimer. Well, both sides were unhappy with that decision. The state thought that the advertising was illegal because of the relationships being illegal and should not continue even without a disclaimer. And Pearl Vision didn't think that it was illegal at all and didn't want it to be enjoined. So both sides appealed. But at the same time, in Consumer Cause versus National Vision, in another case, a court held that a similar plan, which was being run by National Vision in Walmart stores in order to provide optician services and optometrists in the same Walmart locations, the court held that the Knox-Keene law exempted compliance with the Business and Professions Code provisions. So then we had a dichotomy in People versus Cole. The Court of Appeal decided that there was no exemption of the Business and Professions Code. So the decisions were in direct conflict, which led to the Supreme Court granting review in People versus Cole to decide whether or not Knox-Keene exempted the Business and Professions Code provisions. The court heard the case and decided that there was no exemption. So then, back in NAOO, December 6, 2006, summary judgment motions were decided. And the federal court said the statutes are in fact unconstitutional. The court said the statutes were discriminatory because in-state optometrists could provide eye exams and dispense eyewear in a single location, but out-of-state optical companies were prohibited from even having an optometrist on their premises to have co-location between them. So the state appealed.
And this is where we are now. I mean, this is what you're, I'm sorry, I'm just trying to get to the end of the story so that we can understand what our responsibilities are.
This has been a very long and tortured legal history, and we felt it was necessary to give you some background. You probably have it now. The bottom line here is that the state regulatory scheme that outlines allowable and disallowable relationships between the retail commercial side and the clinician have been sustained. We now have the U.S. Supreme Court, which would have followed this, declining to exercise jurisdiction, leaving intact the Ninth Circuit District Court of Appeals decision that says, California, your laws are constitutional. This now places squarely at risk a lot of operational business models for a lot of companies in a multi-billion-dollar industry in California. So Sears, Target, JCPenney, LensCrafters, Walmart, all of these companies now are in discussions with us with regard to demonstrating to us what is their operational plan, and then if it's not in compliance, how are they going to bring it into compliance? Where it affects you is that you operate the registered dispensing optician program, which is part of all of this. Now, to the extent that these companies conform and bring their operational business plans into conformity with state law, nothing will need to be done. If they cannot, then you will also be involved in any enforcement regulatory activities if those need to be taken in regards to the registered dispensing opticians. If it involves optometrists, it will fall to the Board of Optometry.
So just to clarify, are you certain at this point that the practices of those companies you described are all illegal?
Well, we're currently in discussions with all of them.
Okay.
And they have been very forthcoming in providing what would clearly be proprietary information to them for us to do an in-depth analysis of how they actually operate. It's not just the relationship, but it's in the fine detail, the minutiae. How are the optometrists reimbursed? How are they paid? How are they incentivized? Who owns the equipment? Who owns the medical records of those patients? Because those are medical records. What control is there over those medical records? So anything that influences the bottom line with regard to the money flow in the industry is something that we want to look into. I mean, it's nothing new. I mean, Deep Throat said it, follow the money. Where's the money? What's going on? And there are a lot of different players in this industry, and it's as I said, a multi-billion-dollar industry in California.
So will we get the results of your, will we learn the results of your investigate or your determinations?
Eventually, if there is going to be any enforcement action, it will come before you.
Okay, great. Ms. Yaroslavsky, Ms. Wright?
Okay, so I find this very interesting. I know it's been going on for a very long time, but I, as a non-optician, non-optometrist, non-ophthalmologist, but a consumer of all of those things, I guess, want to understand. Currently, the law is that a national organization may or may not have an institution that is available to check and dispense lenses. That's the first question. I just want clarification of what all this, the 10 minutes or 20 minutes, however, what we've heard. What is the law today? Can a national organization own a freestanding or in-house standing place that someone can go, a consumer would go to receive an eye checkup and therefore glasses?
If your question is, Is there a model that exists that conforms with the relationships that are allowed?
I just want to know, what is the law today?
The law does not allow an RDO to own or control an optometrist.
So it
or to
becomes like the
employ.
corporate practice of medicine.
Exactly right.
Okay. So then what you are proposing to happen is that those that are independent operators of the ability to examine and dispense in the same location, owned by themselves, is okay.
Optometrists can do that today, yes.
Correct. I just want to know, I'm only talking about today, not tomorrow.
Right.
And not yesterday, today.
Right.
So as it goes forward, the question is going to be whether or not national organizations will be allowed to perform the services that are currently allowed to be performed by the optometrist.
Correct.
Okay. And the difference between an optometrist and an optician is one that does the examination and one that makes the glasses?
Or sells the frame, fits it, yes.
So optometrist only does the exam, and the optician only does the implementation?
An optometrist in a solo practice can do the exam and sell and fit the eyewear. They usually use outside labs to grind.
They're in charge?
Yes.
Okay, so
But an optician cannot do an eye exam.
Correct.
Right, I got that. So where is it going down the road? What is it, given all of these challenges and all of these, whatever you've explained to us, what is the new model that people are looking to think about, possibly maybe a good idea?
Well, so long as you have the concept that the end result and goal is to have cohabitation, co-location between the optometrist and the retailer, so long as the relationships between those two are appropriate and not prohibited, so that there's no undue influence or exercise by the commercial interest on the optometrist, that's probably the ideal that everybody's trying to get to. But that's a difficult prospect when, you know, if in the past, for example, the optometrist was compelled to only spend so much time with the patient, to issue 4 prescriptions rather than 1, so that the sunglasses, the polarized glasses are also being sold, so that the proprietary contact lenses are also being sold. Those kinds of practices are things that actually influence the consumer in the end in a negative way.
So what you're trying to prevent is the number of tickets that are being written during the day by law enforcement. You're trying to say that you have to be independent of that, correct?
Correct.
And as far as that goes, that's between today it's not between the owner of the facility and the entity, the national entity, and that's what you're trying to protect, correct?
That's correct.
Okay, I just want to make sure I understood. Thank you very much. Apologize, thank you.
Okay, I just want to understand what your process is going to be. You're going to conduct an investigation, and then do you, before it comes to us, do you have them enter into like something that might be a consent decree, or say, yes, we're going to stop this part of our practice that could be in violation of the regulations, or does it come before us and then we enforce that?
No.
I'm just trying to understand the
Good
process.
question. It would only come before you if we've reached an impasse where we have determined that they're in violation of the law and ask you for enforcement authority against, for example, in your instance, it would be the RDO.
Okay. And so otherwise, though, it will have to come to us?
Right.
Absolutely, okay.
Ms. Kirkmeyer had a...
So I just wanted to provide a little bit of clarification. So for the last however many years, we would receive complaints against RDOs, basically stating that they were in violation of the law, the 655 and 2556, and that they had an optometrist, they were co-joined. What had happened under this case was that we were actually enjoined from taking any action against these for a significant amount of time. I don't know, Mr. Terrazas, you can probably give me more of the time frame, but it was a good point of time. We couldn't take any action. When this case became resolved, it allowed us to take action, but it gave a 6-month window, I believe, for all of the RDOs, basically who have been in violation this whole time, to then meet with the Attorney General's office and try to come into compliance with their practice models to where it now is in compliance with the law and not in violation where they had been in the past. So the Attorney General's office right now is working with those entities, and what Mr. Terrazas is saying now, and Ms. Schneider, is that Now we can actually begin to pursue cases where individuals are in violation of the law. That enjoinment has been lifted, and we can actually move forward. However, they are still trying to work with the entities to bring them into law. But if we do get somebody that decides they no longer want to comply with the law, we can pursue that. We will probably work with the Attorney General's office on the licensing side because they do the optometrists and they're more familiar with that practice. And we've actually agreed that that's fine with the Health Quality Enforcement section for Mr. Terrasas' group to look at that. If those cases were to happen, though, where the medical board comes in, if it did go through the disciplinary process and we have to take disciplinary action to revoke one of those licenses, that will come to you through your voting in your panels, similar to you would have anything else that comes before you. So that's what's important for you to know on your side and how the registered dispensing opticians work. And when you're looking at those laws to determine if there was a violation and you taking action, that's where it's important for you to know kind of the history of this lawsuit.
Thank you.
Great, thanks very much. Any other comments, questions?
Yeah, after going through all the torture, I'm wondering if, do we, the medical board, involved in licensing eyeglass store in Walmart?
The registered dispensing optician program is part of the medical board.
Yes.
I mean, not the center itself, but the opticians.
Yes.
But anybody licenses the vision center in Walmart or in, who licenses that?
You do.
We do.
So there's different types of licenses under the RDO program. So there's the registered dispensing program that is, or the registered dispensing optician, who is the bricks and mortar building. They're the ones who's dispensing it. They're the location, basically like an establishment license. That's one that we have. Then within those facilities, you have the registered spectacle lens dispenser. You have the contact lens dispenser. And those are the ones that are basically fitting the glasses and doing the work of it. And then the third group that you have, which is kind of outside of this, is the non-resident contact lens dispenser, so basically the out-of-state individuals. So all of those fall under the board, and you will see from time to time a case come before you against a contact lens dispenser or a spectacle lens dispenser for action, and we do take action and we'll revoke those licenses. I think why it's so familiar, because they're so few and far between sometimes that it gets to that level. We do a lot of citations and fines, but of course we weren't able to do that during that time that we were enjoined from it. So, but it is something that you will see come before you. And again, probably the reason you haven't seen a lot of it come before you is because we have been stopped for a while, which is probably going to change in the future.
And one of the reasons we put this on the agenda was because it was a surprise to some of us, including me, that this was part of our purview as the medical board. So,
can we get a copy of this presentation?
Yeah, I was going to ask, really appreciate your time and education. I find it very, very interesting. But because short time, maybe you can, with our staff, create a detailed memo so that we know the history, the background, the development, and what is the stacks for our education, so we know what is going to come up.
and thank you. And it would be helpful if the board members could get copies of the presentation. Thank you so much.
That's easy. We can do that.
Great.
Well, thank you for your time.
Wait, don't go away yet. Any other board member comments? Any comments or questions from members of the public? Seeing none, thank you so much. And one of the board members said they feel like a lawyer after that presentation. You know, MD degree is an omnibus license, so. We're going to move now on to agenda item 25. Mr. Shunke. Update on licensing outreach and education program.
Good morning, Dr. Levine and members. Just a quick report on the licensing outreach program. Since our last board meeting, before we moved into the holidays, I had a large event down at Kaiser in the Los Angeles area at their main hospital, which brings together the residents from all the various Kaiser facilities in LA. And also went over last minute to UCLA. Initially, the staff, due to other obligations, weren't planning on hosting an event during the fall. They're so big, we usually have 2 events there. But the residents spoke up and said that they wanted a license fair held. So in response to the residents' request, the GME office did so. By now, I've scheduled most of my travel for 2014. I have events already on the calendar through November of this year. As always, in keeping with the governor's executive order, I'm trying to keep my travel consolidated. So when I schedule the larger hospitals, I then contact the smaller regional hospitals in the area to try and make the medical board's presence seen there. And again, in anticipation of what's on my calendar so far, I'll probably be meeting with 2,200 to 2,300 of the unlicensed residents as they begin the licensing process. So that's close to 1/3 of our entire applicant pool for the year. A lot of my time during the last couple of months has been spent helping hospitals and the applicants navigate the Breeze system, the new system, navigating the system, getting them up to speed, and getting the information to them that they don't have available to them anymore under Breeze. And I think all of us at the medical board are doing what we can to help the clients, help the applicants, help the hospitals, so that the licensing staff, the licensing technicians, everyone who works for Mr. Warden, so that they can focus on their work in reviewing and processing files.
Great, thanks very much. Any questions? Yes, Ms. Yaroslavsky.
How did you find the residents, anything about how they're accessing the Breeze system? How were they finding it easy to use? Are they finding it, can you give us some input as to how is it going out there in the field?
I believe that the application process, anytime you transition to a new system, there's a learning curve. I think that the application process seems to be working well. The rest of the system for both hospitals and applicants is a bit challenging.
Okay. Challenging meaning they're making suggestions where we can improve, or I'm finding it challenging, so I'm wondering about the novice, how they're finding it, to be honest with you, and is there an opportunity to start tweaking the system yet or not? We're not there yet, or
of course we're taking all
or?
the input from them to make improvements to the system. The applicant, if you remember our old system, the WAS system, where an applicant could look up the status of their file online.
Right.
In these initial phases of Breeze, that's totally absent from the system. Our applicants cannot look up and find out what the status of their file is, what's been received, whether or not it's been reviewed. So they're totally in the dark. Once they receive a deficiency letter from us and have tried to secure the documents that we need, they have no idea what's coming in, what has been received, whether or not it's been reviewed, and their only avenue is to call me. They can call the licensing technician, but hopefully if we divert as many of those calls as possible to me or to others or to our ISB staff, it requires an individual phone call. And the hospitals, the hospital administration is running into a problem because they used to always be able to keep track of all of their applicants using the Breeze system, so they don't have that resource. And
Let me help just a little bit. So there's two things, as Mr. Shunke said. The first is that the individuals do not have the ability at this time to get in and check the status of their their application like they have been in the past. That's something Mr. Warden and his staff are working on with the DCA to get that in. The system, the way it provided the information, if we would have put it onto the web lookup for these individuals under the BREEZE system, and it would have been confusing for them. So they're working on the different definitions of what it means when something is missing from your file. It will never have, like we did have, where it showed that something is reviewed or received but not renewed. That's something probably a little bit further down the line, but it's something that we're going to request a change for, that there's an intermediate where it's been received, not reviewed, and then reviewed and maybe deficient after its review. We're working on that, but again, everything takes time in putting them forward as changes. The other thing that that we haven't been able to do, and we're not going to be able to do, is in the past, the applicant would provide their ATS number and their ability or their password basically to the hospitals to get in. That's no longer going to be available to them. I guess they could do it, but we don't recommend it because each applicant now, once they log into the system, that is going to be their login when they're an applicant, when they're a licensee, et cetera, through the remainder of their process. So that's where we want the applicant to be able to log in, and then they provide that information to the hospital as to where they are in the process. So that's a little bit different than what's been done in the past, but all of it we are working on, and again, Mr. Warden is working on those definitions, his staff is working on those definitions to get them in the system.
So I thank you. It's not that I'm concerned that you're not working on it and that staff is not working on it. My concern is that from the public perception, we've gone through a licensing debacle in the past. I want to make sure that we're not going to get there in the future. And my concern is the undue responsibility and stress for your staff as far as answering phone calls. And do you have the staff? Yeah, I'm just concerned that in the process, and as well as how long do you have an idea as to when it's going to work? When is this computer system going to work?
This is a very good question, and I think one thing that might help the board is for our next meeting, a catalog of gaps, changes. Well, okay, but to understand from a functionality perspective,
right. What's different?
Not a technical perspective, but a functionality perspective, where the gaps are and what the anticipated date of the release that might address it, if you know it, so that we understand. Again, I don't need the code, but we understand what functionalities.
I want to make sure at the end of the day that the system is working. I just would like to know, is it going to be in 20 years? Is it going to be in 6 months? And what is the implication on our staff? As well as, I think it's interesting, the idea of a unique identifier number, which is kind of what I'm hearing, which is something that we need to examine other entities with what we're doing, especially in the overprescribing area.
Right.
So thank you.
And the other thing is, right now, we are bridging that gap. As you'll hear from Mr. Warden soon, we anticipated this, as everybody knew before we even started the the whole BREEZE system. We said that it was going to be probably at least 6 months before we would see maybe a down curve on the amount of time that it was taken to process applications. And actually, I think Mr. Warden is going to report we actually have kind of almost reached that top right now, and we're now finally going down. It's not been easy. Staff has had to do more work, and had to write up all the requests for changes, but they did, as you saw in, I think, the updates that we gave, we were beyond our goal in processing those applications due to a whole caveat of things, including learning curve, just the functionality of the system, the workarounds that they're having to do, and that they have to enter more information. So all of that kind of obviously had a head when you start any new system, but they have worked on that. The licensing program managers have actually worked on business processes where they can kind of mitigate some of that, and they're pitching in. And again, I can't just thank our ISB staff enough because they're taking those phone calls. So that workload was kind of shifted to a group, a different group to help out in that unit. So we are aware of it and we're working on it, and we appreciate your concern because, you know, we have that too as well.
Thank you.
Dr. Gnanadev.
Mr. Shunke, you're reaching actually thousands of young physicians. I know you're reaching on behalf of licensing. Can you spend some time with them on behalf of enforcement and educate them what dumb things they can avoid so that they won't get into trouble? I mean, prevention is nothing better than prevention. It's not just the quality care issues. It is simple things. They don't even know that those things are not really, they are considered unprofessional conduct.
My outreach to the teaching hospitals actually takes two avenues. One that you're familiar with is the licensing fair, where I sit all day with the residents, with a photographer, a notary, and a fingerprinter, and actually start the application process. And there are some of the larger hospitals I meet with as many as 150 residents in one day. But I'm also given the opportunity at some of the teaching hospitals, and as you've seen at Arrowhead when you joined me, is either during grand rounds, during new resident orientation, opportunities, brown bag lunches, opportunities to go in and introduce the board and our function. And at that point, it's more of a speaking engagement with them. And I do touch on some of the more frequent problems that face those in the medical profession, types of issues that are probably the three main categories that raise concerns and rise to the level of an enforcement action, and present that information to them. In one of my presentations, I literally had a medical resident ask me, what does the medical board care if I've had a DUI? They don't understand the implications of what their actions are and how it can impact their ability to get licensed in California.
Thank you, Dr. Yip.
I think some of the board member willing to go with you when you're in the area to join you in that, right?
So I would recommend going back on what Dr. Yip just mentioned to Dr. Ganadev, is that the board members receive a list of the dates and locations that you're traveling for the year. And if there's a way that board members can show up and come for a few hours, it's a very beneficial opportunity, not only to see what our staff is doing, but to see how welcome and how important it is to the effect of what we're having at the site. The absolute changing the atmosphere and changing the culture, which is creating an opportunity for us to do better at what we do. So I
think it speaks that, as I said at the beginning, UCLA got into a busy schedule and they were going to pass over having a licensing fair, their first licensing fair at the year, and the residents spoke up and commented to Dr. Parker, commented to Sharina in the GME office and said, no, Kevin needs to be here, Kevin needs to help us. So that's the communication among the residents from one class to the other, to the subsequent classes of unlicensed residents, that there is a service that we offer.
I am speaking from experience. I've been to one, and I was very, very impressed at what I saw, but I was more impressed to see that from the administrative side, the deans and the staff in the medical schools, how appreciative they were that someone was actually taking a go-forward basis instead of a retrospective perspective, given what's going on. So I would just recommend anyone try to participate they can.
Great. Dr. Lewis?
Yeah, and I echo that too. I know I sit on the respiratory board, and the respiratory board tries, when they hold their meetings, they try to let the respiratory programs know where we are going to be at a specific time, when their board meetings are, and they invite them to attend. And this is a way for us in a group to interact in some way, at least to put a face, and there's a medical board, and there's real people out here. So I think that in the future, if we could encourage those kind of interactions.
I reach out to the teaching hospitals at which I do have regular contacts, let them know already at the beginning of the year as the board meeting dates are set. I do this similarly to what Ms. Simoes does with legislative staff when we're in the area. We're always reaching out to others to come join us as their own schedule allows, because there is something to be learned.
I know our next meeting is in Los Angeles, and there's several medical schools there that we could remind that we're going to be there.
In Los Angeles, I can guarantee you will meet some of the people from the world of GME.
Great, thank you.
Any questions or comments from members of the public? Do I have I'm sorry, have you?
I have the slip. They said we could make it out afterwards,
Sure,
as long
go
as we
ahead.
made it out. I just would like to make Kevin into a movie star. It seems to me that YouTube would be a good way to do what we're talking about in terms of outreach. And if the medical board isn't comfortable with that personally, maybe a Friends of the Medical Board group could get together and create a public accessible source of information so that it became more widely known what the rules were relative to medical practice. Thank you.
Thank you very much. Or a teenage offspring of a medical board person, yes.
In our mind, he's a movie star already. So.
Okay, we're going to move on to Mr. Warden. Licensing Chief report.
The licensing program has faced some challenges in the second quarter of the fiscal year, as licensing has had staff out for various reasons, including extended leaves, position vacancies. However, the most challenging part has been the implementation of the new Breeze computer system. And we also not only have that, but we also are required to enter in additional information into the system that we previously weren't doing, but that is actually necessary because that will help us be in compliance with one of our sections of law. So that's where we're sort of at with the staffing. The statistics are in your packet on board pages BRD 26A4 through 26A5. You'll notice that most of the statistics that are normally provided in previous reports are not included due to these reports for the statistics are not available at this time. However, I will point out some notable statistics that are not part of Breeze or were obtained by manual count. Our Consumer Information Unit, which is our toll-free call center, received 8,542 callback requests. That is 2.2 times higher than the previous quarter. And that's sort of the results of Breeze. The number of physician licenses issued was 849 for the quarter. This number is a decrease of 598 licenses from the previous quarter and a decrease of 415 licenses compared to last year at the same time frame. As far as Breeze, I'm going to go into a little bit. The Breeze update, as Mr. Chunky stated, prior to Breeze, we had the WAS system, which allowed the applicants to sort of have a better idea that where they might not have sent something in or we didn't receive something. That currently is not available to them, which has also resulted in a large number of increase in phone calls that he was talking about. At this time, currently, Breeze does not have that feature, but staff is working with DCA to get that resolved to where it will be somewhat similar. Right now, that is not available. Currently, with the learning curve, additional information required, and workarounds, it takes more than twice as long to enter information into Breeze than the previous systems. Our time frames for reviewing the applications before we started with the Breeze system was in the 35 to 40 day range. We hit as high as the 90-day range with Breeze. With a lot of staff ingenuity, a lot of overtime, we are able to say that we have reviewed the initial applications for both the U.S. and the IMGs down to the end of December. So we still are a backlog of our incoming mail, but but that's our next challenge. Some of the procedures we have assisted with staff, this part of this was, I don't know if it will work entirely or if it will be something we put in permanently. But because we're fortunate enough to have staff who are able to identify needs and changes quickly, we are able to implement those. And when something works, we identify it. When something isn't working, we identify that and make a change as necessary. We, and the managers, myself, our lead analyst, and our ISB staff are key to this. And so they've all worked very hard. As you'll see, the callbacks, we return every callback every day before we go home. So that being said, that means we work the call staff up to 6 o'clock, and that means managers work beyond that for those calls, as late as 8, 8:30, and sometimes 9 o'clock at night to return those calls. So that is some of the effects of Breeze, and that's some of how we are dealing with that. And it's amazing when you call somebody, you think you're calling too late, and they're just happy you called them back. So it's very interesting in that. But Breeze has been an extreme challenge for us. We've identified one of the things that I believe will help our staff with that is each staff person having 2 monitors. And that will assist us with how we enter information into Breeze, because some of the information we are entering, we're taking from the ACGME website, and we can cut and paste it. But if you have to switch back and forth between screens, you sometimes lose where you're at and how the Breeze system works. So if you have a separate screen for the ACGME stuff, you can just put it into where it belongs. That will be a time saver. We're looking at that. We're also going to test whether or not one touchscreen monitor for each of the staff would help speed things up too. And so that's some of the things that we have identified that will help our staff, and we are continuously looking at our processes, which we provide ongoing training with all the different workarounds. When workarounds are no longer needed, we provide that training, so that this is a work in progress, and we'll be working on that. We had to get our numbers down because we're in the busy season, as we now need to prepare for all of Mr. Chunky's licensing fair applicants who need their license by July 1. So.
Great. And I'm going to, before we have comments, I was going to ask you to go on to the proposed resolution.
Okay.
And explain that, and then we'll take comments on all of it.
All right. So for...
And by the way, kudos to your staff. A human bridge is a very... I understand its necessity, but it's an expensive way to get work done, and their efforts are much appreciated.
They've all have chipped in very hard for that. So, we have a resolution from the board for what is a passing score for our USMLE exams. We used to use USMLE used to provide us a 2-digit exam and a passing score and a 3-digit number. We had a 2-digit passing score of 75, and which we had adopted as our passing score. USMLE no longer provides the 2-digit passing score and only provides us the 3-digit passing score. So we need a resolution from the board to accept the Federation of State Medical Boards and USMLE's determined passing score as ours, and we also request that you have board staff look into possibly creating a regulation so we don't have to continue doing this. So,
okay, do you have proposed language?
Yes. First off, for the first motion, I would like a motion for a resolution to adopt the FSMB USMLE minimum passing score as the board's passing score for all steps of USMLE's physician and surgeon's licensing exam.
So moved.
Second.
Okay. And for the second motion,
maybe we should
probably should
one at a time.
Okay, discussion on the first motion. Any questions or concerns?
So the only question I wanted to ask is that it's not changing anything, whereas before they had the minimum standard and we accepted it, or maximum standard, and that it's going to continue.
Correct. We were, what we had before is they provided 2 different scoring systems.
Right.
They reduced it to 1, and we need to match that.
But that 1 is not lower than what we would have accepted prior.
No.
That's why I just make sure that, okay, thank you.
Any other questions or comments? Any questions or comments from members of the public about this? Okay, proceed.
Okay. I think you might need to vote.
Right. We have a motion on the floor. All in favor?
Aye.
Opposed? Abstentions? Okay, sorry, Kurt, proceed.
That's okay. The second motion I like is for the board to authorize staff to proceed with the rulemaking process to either amend an existing regulation or add a new regulation to address the minimum passing score for licensing examinations.
So moved.
Second.
Any discussion? Any questions or discussion from members of the public? We have a motion on the floor. All in favor?
Aye.
Opposed? Abstentions? So moved. And now we can go back to any comments on Mr. Warden's presentation on the licensing chief's report. Ms. Yaroslavsky.
I wanted to echo what our president had to say about kudos to you and your staff for getting this all done and under your belt and everything. My concern, though, still is that you have the ability to, if the executive director sees fit, to do additional BCPs. My concern is that I'm just so fearful and overcautious of ever getting into the situation we've gotten in before. And when I heard that the numbers had gone up to 90, but we're back down to, I didn't hear what they were back down to on the initial review.
They're down to around 45.
So we're still okay. Then we're getting back. So we're not going to see it spike up again, correct?
Well, I can't guarantee that because we're in the busy section right now.
I just wanted to make sure everyone heard that. So that's my concern. My concern is that regardless of what's going to happen with the busy time, that this board is supportive of not only your efforts previously, but whatever it is you need and our ED needs in order to ensure that we are not going to ever be found in a position of being worried about what's going on, as we have been in the past.
Right, and right now the reason we're at where we're at is because of the amount of hours staff are working. So,
well, you're paying an awful lot of time and overtime, and I understand that. We've done that before, but after a while you guys are going to have burnout, and that's my fear.
That's true.
And what we will do is the time to write concept papers is coming up. So we will look at how much staff is needed now with the current system, taking into consideration a lot of it is learning curve and all of that, and determine if we need to put a BCP forward for our licensing unit for additional staff or maybe even temporary help in the interim time. So we will look at that.
And I'd like to say, basically our learning curve is done at the moment. We've spent the months doing our learning curve. And now we're just fine-tuning our processes and updating whatever workarounds that have been implemented that are no longer needed get to the individuals. But the learning curve, I'm confident that the staff knows how to use Breeze. We have excellent trainers. We have excellent. I know how to use Breeze inside and forwards. I can use the other system inside. Probably even less than Breeze, but Breeze still takes me longer. So that's where we're at. The system, the additional information is different and requires more time.
So let me ask you a question on the website under licensing, because I was just looking it up to see, is there any additional, I can't tell you how much I appreciate that you're returning every phone call every day. But is there any other information that could be put onto the website that might alleviate those calls or the need to call, or some kind of a feeling of more security among our licensees that business is being taken care of? I just want you to, when you have a chance, to take a look at it as an opportunity. I'm not asking for the answers now, but just to look at an opportunity that if there's additional opportunities for the website to give more information or different information or additional information or whatever you feel necessary, that use it.
Right, and we look at that all the time, and And when I say I return all the callbacks, it's from the call center. The staff doesn't always get all their calls returned that same day. So that there is a difference between the call center callbacks and what the staff can call back. So there is a difference in that. Most of the calls are coming through the call center, and that's where our ISB staff is also taking a lot of our calls. So we have multiple people taking phone calls and returning those calls. So, but as far as the phone calls to the individual staff members, Mr. Chunky's taking a lot of those calls for us and getting back to people, but the volume of calls that we have is more than we have staffing for.
So what we have done, it's been nice with having our ISB take a lot of those phone calls. So what they're really looking at is what we can do for FAQs. And so we just recently put on an FAQ, basically, or frequently asked questions or helpful hints to process through the Breeze system for our individuals. That was really for our lookup and also for our renewals. And so we recently just released that. And that's one thing, having a central location, they can identify those issues and they keep a really good tracking log of the calls that are coming in, so we can continue to try to help those that are getting in and using the system.
Thank you.
Okay. Thank you very much, Lee. Oh, Dr. Gananda?
Yeah, Mr. Warren, I am hearing from medical staff members their problems with the renewal I'm talking about. And I can tell you that 2 years ago when I renewed online, it was truly a breeze, but it was an old system. But now I'm scared to death to go to Breeze to really renew mine. I thought maybe I'll wait long enough that you guys fix all the problems and then I'll renew my license before it expires. So it's worrisome to a lot of medical staff members.
I renewed my license with great trepidation. It took 2 minutes, the whole thing.
So you're either going to fall into two categories when you renew.
So there's either
Dr. Levine's category or the other category, which is not a breeze for those individuals. So
it's a balancing act. It's not a breeze. It's just a balancing act.
Right. So a lot of the renewals have to have, that used to be done automatically, have to have staff assistance.
That's what I was told, yes.
Okay. Any questions or comments from members of the public? No, thank you so much, Mr. Warden. Great. And we'll move on now to update on the outpatient surgery setting task force and consideration of recommendations relating to peer review. Dr. Gananadev and Mr. Serrano-Sewell.
Yeah. Thanks. Thank you, Madam Chair, and I'm going to make the presentation. On January 22nd, the Outpatient Surgery Task Force, myself and Mr. Serrano-Sewell and board staff held a interested parties meeting regarding the proposed amendment to the OSS statutes and regulations. The OSS Task Force meeting was held at the MBC headquarters in Sacramento and was video conferenced to 3 MBC offices located in Cerritos, San Jose, and San Diego. I can tell you, actually, that video conference worked really well. And even Mr. Serrano-Sewell participated from San Jose, and I think Julie participated from San Diego. It was wonderful. The OSS task force provided the interested parties with language and reasons for the recommended changes to the statutes and regulations and requested input on these changes. On October 2013 board meeting, the task force was authorized to move forward with its recommended changes after receiving and considering input from the interested parties at the January 22nd meeting. Based upon the comments from the interested parties on January 22, 2014, the OSS task force determined 3 legislative changes could move forward. Therefore, the language for these changes was provided to Senate Business, BNP, and Senator Lieu. And there was a very tight deadline for us. We had to provide within a day, I think, language. So I think we did not do all the changes, but I will explain, and we still haven't given up on the others. The task force recommendations changes were, number 1, section 1248.15A2D, I hate reading these section numbers, providing some cleanup language Number 2, Section 1248.3A, requiring initial certifications of accreditation to be valid only for 2 years instead of 3. And 3, Section 1248.35B2, requiring inspections after initial inspection to be unannounced. This language was already provided to the Senator's office. In addition to the above changes, the OSS task force determined the board needed to make some confirming changes to the regulations based upon the recent legislative changes. Specifically, changes needed to be made to Section 1314.4 of the California Code of Regulations, Title 16. No comments requiring modification to these suggested changes were received at the interested parties meeting. Therefore, staff will begin the regulatory process to make these confirming changes. You can see page BRD 27-9 for the specific regulatory changes. At the interested parties meeting, there were 2 of the suggested amendments that received significant amount of comments. This first amendment, which received extensive comments, was the deletion of Section 1248.15A 2C3. This recommended deletion would have removed one of the methods whereby OSS can be accredited. Based upon the comments received, the OSS task force has determined that more discussion is needed. You can see that on board item 27-3. The other amendment that received significant input was change to the section 1248.15A6B1, which requires peer review for all physicians in an OSS, even if there is only one physician performing procedures in that OSS. The interested parties requested the board to provide more clarification and also provide a definition of peer review. So the OSS task force has discussed the comments received in the interested parties and has modified the section based on those comments. And you can see that on board packet 27-4. So the task force would like to entertain a motion to approve the proposed amendment to the Health and Safety Code, section 1248.15A6BI, regarding peer review requirements for physicians in outpatient settings.
So moved.
Second.
And could you read the language of the motion that you want?
Yes. Okay, all physicians who perform procedures for which accreditation is required in the outpatient setting are required to have peer review evaluations as defined in the Business and Professions Code section 805A1A, including outpatient settings that only have one physician. For the purpose of this section, a peer review body consists of California licensed physicians who are qualified by education and experience in performing the same type of procedures, who may or may not have privileges at that outpatient setting.
Great, thank you very much. Any questions or comments from members of the board? I have Dr. Bishop.
I'm confused. I didn't know that procedures required accreditation. I thought it was facilities or hospitals. Do procedures require accreditation, Joe? I'm just confused by that language. My ignorance may be apparent. I apologize.
All of the above. Procedures also need accreditation. The peer review, when you give privileges, procedures are looked at each one before they get privileges. So an OBGYN doc won't get privileges for liposuction. Let me put it there.
So accreditation in this context means basically privileges are required.
That's correct.
Okay.
Yeah.
Any other board member comments? I have 2 comments from members of the public. Tina Manassian.
Thank you, Madam President and board members. Nice to see you all again. Tina Manassian. I'm a survivor of medical harm 11 years ago, and I still suffer with the effects. I am here on behalf of the Consumers Union Safe Patient Project a nationwide campaign that's organizing patient safety advocates from across the state of California as the California Safe Patient Network. We are disappointed and concerned to see how few and fairly minor are the changes proposed by NBC's Outpatient Surgery Center Task Force. We urge NBC to apply rigorous oversight, maximum transparency, and wise policy direction in the case of these surgery centers and their accrediting agencies in the areas of 1, full disclosure of information to support informed patient decisions, and 2, maximum protection through high accreditation standards. At the October 2013 NBC quarterly board meeting, it was asserted that requiring peer review at OSSs would make unnecessary a Consumers Union Safe Patient Project recommended requirement that physicians performing surgeries that require general anesthesia in OSSs be board certified and also have hospital privileges for the specialty surgical procedures they're performing in OSSs. According to a side-by-side distributed at NBC's July meeting, only 1 of the 4 AA requires board certification now. In early testimony before the board, that accreditor referred to this as, quote, non-negotiable item, end of quote. Apparently, the other accreditors allow the physician owners to create their own rules regarding who can perform which surgeries. Consumers Union urges you to add these requirements of board certification and hospital privileges. The board should be aware that the peer review system, as it is in place throughout this country, does not do a good job protecting patients and should not be relied upon to assure patient safety in OSSs. Even with our current peer review system, which this board is proposing replicating in OSSs, 1 in 4 patients is injured in U.S. hospitals. We have questions about how the board's proposed new peer review law would work in OSSs. A role of peer review is to approve or disapprove staff privileges. How would a peer review process be enabled to remove staff privileges in cases where there's 1 physician, owner/surgeon, and an OSS? In cases where peer review is done by a co-owner/investor surgeon, does the board envision that surgeon revoking surgery privileges for his co-investor? Also, what information will be shared with the creditors regarding outcomes of peer review processes? And of course, it will be important that NBC have in place a process for receiving 805 reports from OSSs. At the interested parties meeting, board member David Saran-Sewell raised questions regarding what NBC could undertake to have confidence that AAs are doing their job conscientiously. We recommend that in cases where the media or the board uncovers a troubled OSS, the board should ask AAs to explain whether they have encountered and addressed the problem. If not, the board should consider appropriate action against the AA. Generally speaking, a more publicly accountable relationship will be one where NBC's actively asserted direct responsibility for what happens at OSSs, a relationship like CDPH has with its licensees. Thank you.
Thank you. And Carol Moss from Outpatient Surgery, Consumer Union Safe Patient Project, sorry.
Hello and thank you. My name is Carol Moss. I'm actually a member of the HAI Advisory Committee for the Department of Health, representing consumers. And today I'm representing consumers with the Safe Patient Project from Consumers Union. Lapses in infection control at outpatient surgery settings put patients at risk. The medical board should assure that creditors are required to ensure that outpatient surgical settings are following prevention standards as established by national experts like the CDC and CMS. Additionally, the law should require all outpatient surgery settings to report on healthcare acquired infections that occur in its patients. This could require a 30 to 90-day follow-up with patients. Several states today, Colorado, Missouri, Texas, New Hampshire, and New Jersey, Oregon, and Texas already have laws requiring outpatient surgery settings to report their infection rate. My husband and I were sponsors on the Niles Law, which is SB 1058, which requires preventative measures and public reporting of infection rates here in the state of California, and we've seen a significant reduction in infections because of that law. So we'd like to make sure that it's included in the safety that people get in an outpatient surgery setting as well. Thank you.
Thank you very much. We have motion on the floor from Dr. Gnanadev to move the peer review language. So can I, if there are no other comments from members of the public, can I have a vote? All in favor, say aye.
Aye.
Aye. All opposed? Any abstentions? Dr.
Madam Chair,
Gnanadev.
that includes others too, like 2-year initial accreditation.
Right,
what I
sorry.
read was only on the peer review.
Right, all three parts of your
Yes.
motion, sorry. All right, thank you very much, Dr. Gnanadev. And the outpatient surgery setting task force is continuing to meet and to work on additional elements of the work in increasing consumer protection in outpatient surgery settings.
That's correct. As I mentioned, that after the hearing, we had about 1 day to put language into the bill, and we haven't. That won't be our last time we're going to put the language in. We are still working on other aspects.
Great, thank you very much. Ms. Simoes, update on legislation and regulation.
Please refer to tab 29 in your board packets. The first item, agenda item 29A, is the status of regulatory actions. Do any members have questions on the matrix? They're basically the two regulatory packages that we discussed at this meeting, so it's just the update on the status. Are there any questions? Okay, moving on. Agenda item 29B is 2014 legislation. The 2014 legislative session has started, and the bill introduction deadline is not until February 21st, so we will have many more bills at our next board meeting. And I believe Lisa was going to pass out updated tracker lists, but basically what I did is just some bills died, so I took them off the list. I've also included a 2014 legislative calendar, and this calendar just shows the legislative deadlines throughout the year. So onto the tracker list. The 2-year bills are in blue, and these will not be discussed at this meeting. There are only 2 bills that we will be discussing at this meeting. So let's move on to the first one. AB 1535 Bloom allows pharmacists to furnish naloxone hydrochloride in accordance with standardized procedures developed by the pharmacist and an authorized prescriber acting within the scope of his or her practice, or in accordance with standardized procedures or protocols developed and approved by the Board of Pharmacy and the Medical Board of California. This bill would require a pharmacist to complete a training program on the use of opioid antagonists that contain at least 1 hour of approved continuing education on the use of naloxone hydrochloride before furnishing. Drug overdoses are now the leading cause of injury and death in the United States, surpassing motor vehicle crash deaths. The board supported AB 635 from last year because it encouraged licensed healthcare providers to begin prescribing naloxone to patients on chronic opioid pain medications in order to help address the prescription drug overdose epidemic, which furthers the board's mission of consumer protection. This bill would also increase at-risk patients' access to naloxone, while at the same time ensuring standardized procedures and protocols are in place. Board staff is suggesting that the board support this bill, but I need a motion.
So moved.
Second.
Any discussion or questions for Ms. Simoes? Any comments or questions? Oh, sorry, Dr. Gnanadev.
Yeah, you mentioned that protocols approved by both medical board and the pharmacy board. Is that correct?
We're kind of similar to the advanced practice pharmacy bill that Jenny kind of made mention to, where we have to approve some protocols. So I believe the process would probably be the same, where we would work with the Board of Pharmacy to come up with those protocols, and then the Board of Pharmacy would approve it, and then they would bring it to the board to approve that as well.
We've done this in the past with the Board of Pharmacy. And in fact, later on, I'm going to be asking for a physician volunteer to work with representatives of the Board of Pharmacy in development of the protocols we actually have under advisement now.
My next question is there any opposition to this one? Who is opposing?
It just got introduced, so at the time when I checked, talked to the author's office, there wasn't opposition. There's generally support for bills that increase access to naloxone because of all the lives that it's saved.
There actually was some very good media this past week in the Los Angeles media market supporting this, with more than just a blurb, pictures and story, and so it's starting to get some positive spin from what I've seen.
Yeah, I think so. And Kim and I actually met with the governor's office, and I know she included in the update, and Trooper Sanders and Drug Policy Alliance, who's one of the sponsors of this bill, on talking about how important it is to have access to naloxone for patients at risk and their family members and friends. So I think it's a step in the right direction that we should probably support.
Okay. Great. Any questions or from members of the public? Ms. Chung.
Good morning. My name is Yvonne Chung with the California Medical Association. We don't have a position on this bill yet, but we do have some concerns that this bill currently lacks language that would provide safeguards against it being construed to allow pharmacists to dispense prescription drugs without a prescription. As you know, we have previously, we're generally supportive of increasing access to naloxone, but some of the issues that we have identified potentially would be that somebody who is potentially in need of naloxone should probably be under the care of a physician if you're on, enough opioids that, this is a real risk that you might actually overdose. There's also the potential that it says, the bill refers to training for pharmacists, but really it would be, you need training for the person that would be administering the naloxone, and currently it's only being administered by emergency personnel. So we do have some concerns about that as to when it's appropriate to administer naloxone, because just because somebody's passed out, it's not necessarily opioids, and naloxone is only effective as an opioid antagonist. So, it could be alcohol poisoning, and naloxone is not going to do a lot of good. So we do have some concerns about potential delays in care, but we are still looking on the language, at the language, and just wanted to raise some concerns. Thank you.
Thank you. I have four public comments. Have you put in a slip, sir?
I did, yes.
Are you Brian or Philip?
Brian.
All right.
Good almost afternoon, Madam President and board members. Brian Warren, I'm with the California Pharmacists Association. We are one of the co-sponsors of the bill along with the Drug Policy Alliance. We actually I'd almost say that we missed the opportunity last year with AB 635 to further promote its goals of improving access to naloxone, because it's a drug that is incredibly safe and it saves lives. We've so far received support from the Health Officers Association of California, which is a group of physician health officers from the various jurisdictions throughout the state, as well as the California Society of Addiction Medicine. We've received, we're scheduled to meet with the California Medical Association to discuss their concerns. However, I think that a lot of the more specific items in how this will play out will be resolved through the protocols that this board will approve along with the Board of Pharmacy, because that's where some of the more detailed items, such as ensuring that the patient has the appropriate training in administering the drug, will be spelled out specifically. So I'm more than happy to answer any questions if there are any, and I also know that some colleagues from the Drug Policy Alliance are here as well.
Dr. Gnanadev?
Yeah, you mentioned already. I think my suggestion is to make sure work with all the stakeholders. It is a somewhat less dangerous drug, but how you administer and when you administer is the biggest concern I have, because if you have diabetic coma or if you have the drug-induced coma, it's very difficult to differentiate. So these are the issues you guys need to deal with the physician groups, and but the idea itself is actually good, but you need to work out the details.
Thank you, Dr. Gnanadev. Dr. Bishop?
I agree in principle with the whole process. I believe it's a bit of a misnomer to say it's an incredibly safe drug. It's not. This drug, and in fact the package insert specifically says this drug can be associated with severe sympathetic outflow, with hyperdynamic crises, stroke, heart attack. So it's not an incredibly safe drug. It's a drug that has pluses and minuses. I just don't want anyone to get the impression this drug is just easy to do, easy and safe to give. It requires significant training and understanding of the drug as you proceed. So just a bit of a mischaracterization, I think. Just want to clear that up.
Dr. Lewis?
Yeah, I support it in principle. I also have concerns. It is not a safe drug. And I also have concerns that even with proper training, pharmacists may be giving this drug out to people which may share it and share with other people. And it just opens up a whole can of worms without more thought about constructing this bill to be safe to consumers, to protect the public, and to be administered in the correct way. And I just think there needs to be a lot more thought process in this before we move ahead with it. So I support it in principle in helping to save lives, but I think there needs to be a lot more work on this. So
I do think that last year when the legislature passed AB 635, it established the precedent for the drug naloxone, there is no necessary prior medical examination prior to prescribing it, because it allows prescribers to prescribe it not only to the patient that is potentially in risk of an overdose, but also just family members, friends, or any other person who has the potential to help. So it's one where, because it's 100% generic now, there's nobody who's willing to pay for all the tests necessary with the FDA to get this classified to be over the counter. The California Medical Association itself has policy recommending that this drug be reclassified as over the counter, because increased access has only resulted in increased number of people who have been saved from overdoses. I think that we will be working with others, and this board will definitely have the opportunity to ensure appropriate safeguards in the approval of the protocols.
Thank you very much. Any other questions? Dr. Gnanadev?
Yeah, I totally agree that it's not a completely benign drug, but the other side of it, that is, if you don't give the drug when somebody is in overdose coma, that is a serious consequence. That's why we're trying to balance it. That's why for you to work with the appropriate physician groups to really come up with the appropriate protocols is very important. The drug does wonders if you do it compared to complications it can, but it can have serious complications. I don't like to hear that it's a very safe drug. That worried me, but it can be a miracle drug if you do it right. So.
What I'm hearing from the members is that many of you support this in concept, but maybe don't want to go to a full support position yet. We do have a position we can take that support in concept, and as it moves through the process, I can bring it back to you after some work's been with stakeholders and been done, and then maybe at that point we can take a support position, but maybe support in concept would be a more appropriate position at this time.
Could I get a motion?
I make a motion to have a support and in concept stance on this bill.
I'll second the motion.
So,
well, I think you've got a motion. I mean,
we have a motion. You
have a motion, and I'm not so. I have to just put a little bit of parameters around this situation. That our support or support in concept is an opportunity either way for us to be at the table with the assembly member and with the stakeholders. I understand the concerns of the medical professionals on this board as well as CMA, but the responsibility of negotiating this and bringing it all together is the responsibility of the assembly member, and we're just a party to that discussion. The reason to change this has got to be a reason. I mean, the assumption is that legislation is not written by, is usually written by the lobbying groups. And CMA and the Pharmacy Board, and I'll do fairness, you're not bureaucrats this week, you're lobbyists. They're the ones that are writing this legislation. Our determinant factor will be, will we support what they do? So I don't know that to step back is going to benefit us as a medical board. So I apologize. I'm not so sure that I'm willing to withdraw my motion. You might have to vote on the first motion and see if that passes.
We have two motions. Ms. Jaroslavsky is perfectly within her rights to not withdraw her motion. We will vote on her motion once we're ready to vote, and we're not. We have more speakers on this. We will vote on her motion, and then we will vote on Dr. Lewis's motion. So I have Laura Thomas from Drug Policy Alliance.
Yes, I'm Laura Thomas. I'm the Deputy State Director for the Drug Policy Alliance, and primarily I wanted to thank you for considering our bill. We are one of the sponsors of the bill, and it's part of our effort to ensure that California does a better job of addressing the significant epidemic of accidental drug overdose. It is, as my colleague said, now the leading cause of accidental death, and that's true in California as well as in the United States. This type of pharmacy access to naloxone is a program that's currently in place in Washington State and Rhode Island, where they've developed protocols for it. We have a few states to look to because our legal structure is different. It needs to be a change that's made through a legislative process in California as opposed to what happened in Washington State and Rhode Island. But we are not the first ones to be trying this, and given the number of people who are dying every day in California, I feel like we need to be making efforts that we can to move forward with new programs to try and get naloxone into the hands of people who will be at the scene of an overdose. I will also state that as a layperson, I have actually been trained in naloxone use and recognizing the signs of an overdose and knowing how to use naloxone. And that training that I received was in accordance with protocols developed through the San Francisco Department of Public Health and the Drug Overdose Prevention Education Project, which does train lay people in how to recognize an overdose and use naloxone. So we have a long history of training lay people and peers in how to use this.
Thank you very much for your comments. And Mr. Philip Kaufman, or Dr. Kaufman?
Hi, I'm an internist and an infectious disease clinician at University of California, San Francisco, and the San Francisco Department of Public Health. And I've been doing work on opioid overdose prevention and also involved with naloxone for quite some time. Naloxone has actually been distributed for over 20 years to people who might witness an opioid overdose, starting in various places around the world and then hitting the United States around 1996. It really started to pick up in the 2000s, and in San Francisco since 2003 under the Department of Public Health. There was an MMWR publication a couple of years ago that documented 50,000 people trained in using lay people trained in using naloxone and over 10,000 reversals. About 99.5% of which are successful generally. The safety concerns around naloxone, I think, are actually pretty reasonable, especially with the doses that tend to be used today and certainly that are used in the lay distribution programs. The withdrawal effects of naloxone are actually pretty mild, and all these programs, most of these programs collect data in terms of what the side effects are after naloxone administration, and they're pretty mild. We don't get the violent kind of side effects, violent kind of withdrawal that you used to see when there was 2 milligrams or more of intravenous naloxone administered by paramedics. And most of these use an actually an intranasal formulation of naloxone, which is a much more mild on and off than the high dose intravenous administration. The success of it has been pretty impressive, and the data from the state of Massachusetts are the most remarkable, where there was essentially a dose-dependent, sort of per capita dose-dependent reduction in opioid overdose mortality based on the rate of distribution per capita in each community. In California, we've had a wonderful environment and a fantastic opportunity to expand naloxone availability, and AB 635 has certainly added to that quite a bit. I run a National Institute on Drug Abuse funded study to evaluate naloxone prescribing from primary care clinics in San Francisco, and so we've helped programs start up prescribing, help clinics start up prescribing naloxone. One of the barriers, of course, is the time that physicians have to actually give people information and demonstrate a kit. You have to have kits on site and demonstrate a kit, et cetera. So pharmacists are actually in some ways in a better position to do that. And so I would encourage that as I would encourage support of this bill, because it sort of takes the pressure off in terms of teaching from physicians and helps pharmacists contribute to that discussion and service.
Thank you very much for your comments. Any other comments?
You have 2 more.
Yes, please.
Again, I am in support in concept of the bill. However,
could you state your name for the record,
I'm
sir?
sorry. Harrison Robbins. I am an otolaryngologist and a cosmetic surgeon. I just really have one sentence to make, and that, or one question to ask, and that is the follow-up of the distribution of this drug. If a pharmacist is the origin of the of using this as a treatment, and it's over the counter, then it no longer, in my mind, has a follow-up. And this drug, with its risks, demands a follow-up. So is that part of the protocol where states like Washington and Massachusetts are doing this now? Or will this be added to the protocol here in California for the subsequent benefit of the patients?
Thank you very much for your comment.
Karen Ehrlich. I am the grandmother of an 18-year-old grandson who died of a heroin overdose, an accidental heroin overdose, 2 years ago. I would like to take some issue with the concept of the safety of this drug versus the lack of safety of somebody dying. I appreciate this board's concern with the safety of this drug, but I also believe that we need to stop talking about safety because safety is an absolute. And there are no drugs that have such an absolute. Acetaminophen kills. Aspirin kills. I think we need to start looking at a safety profile rather than safety. And in this context, the safety profile of this drug, I think, clearly is of benefit to the people and their loved ones who might suffer because of these accidental overdoses. Thank you.
Thank you very much. Any other comments or questions from members of the board? Members of the public? Members of the board? We have two motions on the floor. I'm going to ask for a vote on Ms. Yaroslavsky's motion, which is to support a straight support position on the bill. All in favor? 1, 2, 3, 4. Okay, thank you. And any opposed? 1, 2, 3,
Motion fails.
4.
Motion fails.
I'm sorry?
The motion fails.
The motion fails. Thank you. I'm counting. I'm slow.
It was 5 to 4.
So, all right, so on the motion to support in concept, pending interested party meetings and further review of the bill, all in favor?
Aye.
Opposed? The motion carries. Thank you very much. And you have one more bill.
One more bill. The next bill, SB 500 Lou, would require the board to update the pain management guidelines every 5 years, beginning July 1st, 2015. This bill would require the board to convene a task force to develop and recommend the revised guidelines to the board. This bill would allow the task force to consult with the American Pain Society, the American Academy of Pain Medicine, the California Society of Anesthesiologists, the California chapter of the American College of Physicians, the American Cancer Society, a physician who treats or evaluates patients as part of the workers' compensation system, other medical entities specializing in pain control therapies, and specialists in pharmacology and addiction medicine when developing the revisions to the pain management guidelines. At the April 25th, 2013 Enforcement Committee meeting, the committee established a prescribing task force. This task force was convened to further define best practices related to prescribing controlled substances and to revisit the pain management guidelines to address the serious problem of inappropriate prescribing. The task force had its first meeting on September 23, 2013, and discussed corresponding responsibilities of physicians and pharmacists for prescribing and dispensing. As Dr. Bishop said, the next prescribing task force is set for February 19th, 2014. And at this meeting, the discussion will focus on revisions to the pain management guidelines. This bill would simply codify the work that the board has already begun to address related to the important consumer protection issue of inappropriate prescribing. The board has identified revising these guidelines as an important tool to help combat inappropriate prescribing. This bill will ensure that the pain management guidelines are revised and then reviewed in a consistent, ongoing manner to provide appropriate guidance to physicians who are prescribing pain medication. Board staff suggests that the board support this bill, but I need a motion.
So moved.
Second. And I would just like to make a comment that this isn't just about inappropriate prescribing. It's about updating the guidelines so that patients get appropriate pain management based on the best available evidence.
Right, that's true.
I agree. I think it's in my mind, maybe I'm wrong, that mandated pain management which came on early in 2000s actually probably caused overprescribing. So we need to balance it both sides. So you don't want somebody to suffer with pain at the same time. You want to have some control over prescribing opioids for pain management. So,
great, thank you, Dr. Granado. Any other comments from board members? Any comments on this bill from members of the public? Seeing none, we have a motion on the floor to support SB 500. All in favor?
Aye.
Aye. Opposed? Any abstentions? Great. Thank you very much, Ms. Simoes.
The next item, 29C, is proposed legislation. And before we move on to the document in your packet, I would just like to give you an update on the legislative proposals that were already approved by the board. So there's 3 proposals that will be included in the Senate B&P Committee's omnibus bill, which is like the committee bill, basically where the non-controversial kind of technical proposals are included. So the proposal to include the American Osteopathic Association Healthcare Facilities Accreditation Program as an approved accreditation agency for hospitals offering accredited postgraduate training programs is going to be included in that bill, as well as the proposal to strike scheduled from existing law in 2240. Where existing law basically says a physician who performs a scheduled medical procedure. So that change will be included. In addition, a proposal related to physician availability that would allow the board to adopt regulations for all clinical settings, not just those performing elective cosmetic procedures using laser or intense pulse light devices. So those 3 proposals will be going into the omnibus bill. The board also approved going forward with legislation that would eliminate the 10-year posting requirement in existing law in order to ensure transparency to the public. In the Senate B&P Committee's background paper, it was recommended that this change be made. However, unfortunately, SB 304 did not include language that had this change. So I do have some good news. Assemblymember Eggman, who is a member of the Assembly B&P Committee, has agreed to carry this legislation. And so it's not in print yet, but as soon as it is, I'll let you know. As Dr. Ganadev mentioned, he gave you the update on the outpatient settings proposals and told you which ones are going to be included in Senator Liu's bill. That bill's not actually in print yet, but it will be in print. I wanted to let you know that this bill will also contain language that will reverse the Capon versus Shuri decision, and it will allow physician-owned outpatient settings to obtain surgical clinic licensure from Department of Public Health. So it won't be a mandate or requirement, but it will go back to pre-Capon to give that option. And so this bill will include some language that's sponsored by the board and some language that's not. So the board at the time when the bill's in print can decide, do we just want to be a really strong supporter of that, or do we agree with that and we want to sponsor? When that bill's in print, we can make that decision. I'll also be working closely with Senate B&P staff, G.V. Ayers, who's in our audience right now, on the 805 language that the board just approved to see if that could possibly go in that bill as well. And the last proposal that we approved was...
Chair,
oh, sorry. I'm sorry.
So I'm still trying to get what you said just pass by very quickly. That is that the CDPH can license the physician-owned surgery centers?
Well, it will be language that would allow that, yeah. So it'll basically say that that physician-owned outpatient settings can be licensed by CDPH.
So then they will not be under the medical board.
Well, they could be. It would be their option. So they would have the choice. So they could stay accredited by the medical board, or they could choose to obtain licensure from CDPH. It wouldn't be a mandate. They'd have to have one or the other, but it wouldn't be a mandate that they be licensed by CDPH. They could choose to stay accredited, or they could choose to be licensed by Department of Public Health.
They'd be choosing between accreditation and licensure.
No, I understand that. It worries me that we do all this and make the consumers even more confused than ever. So I'm not sure why we are going with this confusion more than anything else.
Well, I think since the Capon versus Shuri decision, there's been a push to go back to what it was before, to allow physicians that option. It was, a court decision, but it was also a legal interpretation that resulted in physician-owned outpatient settings having to be accredited by an outpatient or by accreditation agency approved by the board. So there's been a push almost every year in the legislature to try to get this fixed. Since then, at some points it was a mandated licensure by CDPH, at other points it wasn't. But I think the main goal, and I guess GV can probably speak better to this than I can, but is to make everything equal standards throughout the board. So if you're in an outpatient setting, this is what they're striving to do. This is the first step of that process. But if you have further questions, probably they'd be better directed to GV than to me, because that part is actually not our proposal. So,
and while this doesn't address it, the long-term goal is that whoever owns it, independent of who owns it, the standards are the same.
Correct.
So the same level of patient safety is provided, whether it's around infection control or notices, whatever, across all outpatient surgery settings, whether they're physician-owned or not. This doesn't do that, but it will create a platform across which standards can be set.
Yeah, just still my point is, I think you can set all those standards, but make it a little easier for the consumers to go to one place or the other, rather than getting confused. Oh, who controls this one? How do we go? Where do we go? So it just makes it, you can make the standard same for everyone. That should be same for everyone. But giving these options and all that, I thought it was getting even more confusing.
I just want to add my support to what Dr. Gnanadev is saying. I think we hear from the consumer groups frequently that when they have a complaint, who do they go to? They have no idea, and they want us to put on our website who to go to, but this adds another level of confusion, I think, unless it's done properly.
Mr. Ayers.
GV Ayers with the Senate Business Professions and Economic Development Committee. Yes, we are intending to have the language, which would be authored by our chair, Senator Lieu, that Ms. Simoes referred to. And that's an issue of concern for us as well. That is, where consumers go, we don't want to confuse consumers on this. And we're not, the language that was discussed is not something that is ironclad with what we believe that it will be in the very end. Can I say, yeah, that's the way we're putting it. We understand the issue of clarity there. That's also an issue with us as well. So we're seeking, as the legislation goes forward, to resolving those.
So as a point of clarification, what I'm hearing is that there will be the exact same of everything. It will either be called certification or it'll be called accreditation, but the requirements to receive either will be the same. Is that correct?
That's what
That's what the aim is. So I just wanted to clarify that for the people around the table. That's what I was hearing, and I just make sure that. So we're all going to the same place. It's just.
We want everybody to have the same rules.
Well, everyone's going to play the game by the exact same rules, regardless of what you call it. The issue is, with under one opportunity or entity, you might not be as visited as often, but you'll be required to the same requirements.
Yes.
I do just need to make sure we're using the right terms, because certification is for CMS. Right. So if you can be licensed, accredited, or certified, or all of them.
Right. And that's true today.
That's true today, Cal.
Sorry, thank you.
I just want to comment. I mean, I know that Dr. Gnanadev has done a lot of work on this, and and the staff has done a lot of work on looking at all the different accrediting agencies. So I just hope all that work has not been wasted. Hope we can somehow dovetail to work together on that, because they've done quite a bit, and to kind of throw that all away now, we'd like to go forward with making that a useful asset to you.
We're not looking to throw the baby out with the bathwater.
Thank
and
you.
we will be working very closely with you.
We will be.
Yeah, just make sure that it's easy for a consumer when they go, they would understand where they need to go. I thought that it was bad enough because of that lawsuit, it all was dumped on the medical board rather than CDPH doing its job. Now we are taking steps to go beyond what CDPH is doing to with the regulations what needs to be, and then we are going to put it back into space which way you go. So that's why it just didn't make a lot of sense to me. And then there is CMS, which does its own certification. So I just want to get the confusion less. Standards can be the same. Absolutely, you shouldn't be, because that's what we want. All the standards for everybody to be same. If you can convince CMS, that will be good. But I don't think anybody can convince CMS. But between CDPH and MBC, there should be same standards. That's not the issue. But don't confuse the consumers. That's right.
So just to dovetail on what we've just heard, we've had almost a full year discussion on whether we should put in doctors' offices notification doctors are licensed by the Medical Board of California, and the pushback, but it is in place currently. And maybe some kind of a similar notification in every surgical center as to who holds the oversight should be also posted exactly the same way with the same point font that was required for doctors. And then this would also then alleviate any kind of confusion on behalf of the consumer or the client as to who they go to if they have any questions or concerns by who oversees that entity. So I just offer that as an opportunity.
No, that would seem to be a good step. A good step. I don't know that is the complete answer, but
no, that is a partial, and it's just that I remember what the pushback was to do that for us. So maybe take away the pushback and just do it.
Right.
I'm sorry.
Dr. Yip?
I'm sorry. I'm really lost. Why do we need two oversight body or accreditation? Why do we need two now?
We currently have three.
Yeah.
We have certification of outpatient surgery centers by CMS. We have accreditation of physician-owned outpatient surgery centers by one of four, now five accrediting agencies. And we have licensure of outpatient surgery centers. Those are not owned by physicians, by the California Department of Public Health. Prior to this lawsuit, physician-owned outpatient surgery centers could have been licensed by CDPH. The lawsuit foreclosed that, which drove all the physician-owned OSSs to accreditation through one of the four, now five agencies. So the current world is we have three, and I think the goal is whoever's licensing, certifying, or accrediting operate on the same rules, and as we've heard several times, that it is clear to consumers when they enter the premises or make a decision who's in charge, what the ownership is, and where they call if they have problems, or who they call. And I think that's all of our intent.
So back it up for 2 minutes for Dr. Yip and for new members of the board as to how this all came to be an issue maybe. That might help to explain why this is all coming forward.
Well, I have that history, but I'm trying to say, when that Department of Public Health licensed, do you also use those agencies for doing the accreditation work? Or you have your own in-house team to do the accreditation?
The Department of Public Health does not use the accrediting agencies to license facilities. Is that correct?
They don't use them to license them, but they use them to do what is called the survey or the inspections.
Like a guideline.
So they have their own team to do the initial survey and accreditation, which is not one of the four. I know CMS.
So what we don't know is that everybody is using the same rules to play the same game. So what we're trying to do is institute the same rules to play the same game, regardless of what the title of that game is. It doesn't matter what the title of the game is. what is happening during the game is people are playing. So in order for people to play and be at the table, they're going to serve under the same rules and oversight. And that's what we're trying to achieve.
And some of this will be accomplished by regulation and
Right.
by, not by this particular statute.
I think it sounds like the board's goals and Senate BMP goals are the same. We don't actually have language yet, but hopefully we'll work closely with Senate BMP staff to make sure that all of our concerns are addressed. So,
Yeah, just to Mr. Jaslowski's point about that having a sign that this doctor is, you can report to medical board in practice. But remember that in physician-owned, even if it is licensed by CMS, I mean certified by CMS, licensed by the CDPH, if a doctor practices there, you will still have that sign. So that's why that doesn't alone solve the problem, because then they see there were two different signs. And I'm just trying to make it whatever is easy for consumer to go and comply to and really deal with it rather than make it more confusing. That's all I'm looking at.
So just a point of clarification, right now, as you know, the physician does have to have a sign posted or have something in their paperwork, but the accreditation agency right now has to have a sign posted stating that they are under, the outpatient surgery center has to have a sign that says that they're under a certain accreditation agency. So there is already the posting of a sign. I don't know, that might be something, Mr. Ayers, you look at with CDPH for their facilities to require a posting of a sign. If they don't already do that, they're under the California Department of Public Health. That's
So you're
just
talking about so that all facilities would have a notice posted on
as to where to go, right?
which speaks to
Absolutely.
Yep.
which speaks to
Yeah. And that'd clarify, so if you're in this setting, it already has a sign posted, but CDPH probably needs to follow suit if they don't already do that.
Yeah, that would seem to flow, and that's something that we
Make it
would,
easy.
that is appropriate for us to look at there.
Thank you very much.
Thank you.
okay, so so moving on to my next update. The board approved going forward with legislation that would require a respondent to provide the full expert reviewer report and to clarify the timeframes in existing law for providing the report. This is an issue that was brought up in the board's sunset review report, and SB 304 did originally include language that would have addressed this. However, after many meetings with the California Medical Association and the legislature on amendments, the language was pulled from SB 304. Board staff brought this to you again as a proposal because we thought we were in a place where we could actually negotiate some language that would work with CMA and would work with us. And I attempted to secure an author for this piece of legislation. However, one of the first questions that's always asked when I just secure an author is, what does the California Medical Association think about this? And so in securing an author, that author's office called CMA to find out what they thought about this proposal. And they basically told the author's office that they were opposed to the general concept of this, and no amendment that we could work on with them would make them not opposed. And so it's very difficult for me to find an author if CMA is opposed to the general concept. So it may be something that we need to work on a little bit more. We thought we were in a different place. We thought that because we had submitted language and CMA had submitted language and we had submitted language again, that maybe we could work on this, but that's not the case. So I don't think that I'm going to find an author for this. It would be different if I had found one and then we were, working through the process, but that's not the case. So I just wanted to let the board know that CMA is opposed to this general concept, which I wasn't aware of before. So,
All right, I have Tina Manassian would like to speak, and then Yvonne Chung. Yvonne, if you could address.
Tina Manassian, Safe Patient Project, Consumers Union. So, Ms. Simone, you just spoke about a bill earlier. I'm sorry, I don't know the number. I have some concerns about it. You mentioned in there that a doctor can go to CDPH or the medical board to get licensed for an outpatient surgery center. So what happens if a doctor goes to MBC, they turn him down, You mean he can go to CDPH now and try to get a license there, or vice versa? He tries to get one at CDPH, and they turn him down and deny him. Then they go to MBC, and they get it from MBC. I have a concern with that. I have a big concern with that. And Dr. Dev, I respect you. I appreciate all that you've done on the committee. But my concern when I spoke at the interested parties, this is a closed case, so I can talk about it. Dr. Efrain Gonzalez, that was a mistake and a disaster. And it was both MBC's fault and AA's fault because his license was revoked in Puerto Rico before coming to California and opening an outpatient surgery center that wasn't accredited yet. So I respect you, and you mentioned this to me at the meeting that it was because he was under CDPH. No, he was under you guys. The MBC licensed him here in California. The other issue that I have is, sorry. Anyways, those are my concerns, kind of like drug shopping, prescription drug shopping. A doctor doesn't get licensed from CDPH, so then he goes to MBC and vice versa. So I have a big concern about that. I would urge you to look into this and not let doctors be able to shop around. They should go to one entity, be licensed by one entity, overseen by one entity, regulated by one entity. Same thing you're trying to do with AA. You're giving your responsibility to the AA to oversee outpatient surgery center when it's your job to license and regulate doctors. Don't rely on them. How do you know they're giving you the proper and correct information? You're going by what they're telling you.
Thank you very much. Yvonne Chung.
Good afternoon, Yvonne Chung with the California Medical Association. We actually wanted to address two parts of the legislative proposal. I don't know if you want me to start with the expert witness issue. Hold on a second, let me.
Go right ahead.
Okay.
You got 3 minutes.
Okay, sorry.
Divide it as you wish.
Sorry, I'm just getting myself organized here. Basically, our concern, it's our belief that in last year's negotiations with, or discussions with the medical board regarding the expert witness issue, we made our concerns pretty clearly known with respect to the changes that were being made to the expert witness proposal. Our belief is that it really does skew the balance towards the prosecution rather than for the physician, and we believe that it's, sorry.
Do you want to be specific about what you're talking about?
Yeah, I'm pulling up my notes here right now. So, in discussing it with our legal counsel, we really do believe that the advantage in terms of the 90-day, the change in the amount of time that the change in the amount of time that a physician basically has to prepare their expert witness defense really is inconsistent with the MBC's burden of proof as required under the Medical Practice Act and for due process. So if your question, I think we've made our position pretty clear that we have concerns about this, and I don't know what else, if there are additional questions, I'd be happy to try to answer them from the board.
Okay, great. And you had another issue?
The other issue has to do with the issue of the 10-year posting requirement and removing that. We just wanted to put it into some context for the board that that language was put in there as part of a prior sunset review process where we had concerns about leaving information up on the website that was potentially ambiguous to consumers and patients about the competency of their physicians. So we do have some skepticism about moving away from that language because it was put in there specifically to address these concerns during a previous negotiation. Thank you.
Okay, thanks very much. Dr. Robbins?
Thank you for allowing me to speak once more. I neglected to say that I'm also on an advisory committee for the medical board, which has to do with MD supervision of allied health personnel and corporate medicine. And I would like to bring to the attention of the board in particular.
Sir, is this relevant to what?
It is.
Okay.
And especially to Dev, that we are right now omitting a huge segment of OSS facilities in our deliberations here. And that segment is responsible for a good percentage of surgical procedures that are being done now. And that is the exception to the requirement for accreditation that is given to OSSs that operate under local anesthesia only. They are not required to be accredited at the present time, and there has been no discussion whatsoever of how these will be included, whether it by the amount of local anesthesia that is used or the amount of consciousness that is affected for the patient in these facilities. And I wanted to make sure that we don't omit them in our considerations.
Thank you, sir.
Okay, moving on to the 29C, the document in your packet. The board raised the issue of accelerated 3-year and competency-based medical school programs as a new issue in its sunset report. In an effort to reduce the nationwide shortage of primary care doctors, there's a movement toward an accelerated 3-year curriculum. This curriculum would allow medical students to receive the same amount of education in a concentrated, modified year-round education schedule. There are some California medical school programs that are proposing or considering competency-based tracks for students that excel and can progress at a faster rate than the standard 4-year program. Some of these accelerated programs will not meet the requirements of existing law, Business and Professions Code Section 2089 to 2091.2, and legislative changes are needed in order to accommodate changes in medical education and to license graduates from the accelerated curriculum programs. All of these proposed programs are going through review and approval for accreditation through the Liaison Committee on Medical Education, LCME, which accredits all U.S. medical schools, or the Committee on Accreditation of Canadian Medical Schools, which accredits Canadian medical schools. Board staff has met with staff from the University of California Office of the President and discussed the need for legislation to accommodate the accelerated 3-year and competency-based medical school programs. Board staff has drafted language that would allow for these programs only if they are accredited by the LCME or the CACMS. Board staff has determined that applicants who graduated from an accredited program meet the minimum medical education requirements. So board staff is requesting approval from the board to co-sponsor legislation with the UC to allow for the accelerated 3-year and competency-based medical school programs. And board staff is recommending that legislation be co-sponsored by the board only if the UC co-sponsors that legislation. I believe that Catherine Nation from the UC Office of the President is here today to provide public comment. In addition, Assemblymember Bonilla has expressed interest in possibly authoring this legislation, and I believe there's Sarah Brady is here from Assemblymember Bonilla's staff as well to talk about this. Thank you.
Thank you. So I need a motion.
I'll move the motion for discussion purposes only.
And a second?
I'll second it.
Great, thank you. Board members have questions for Ms. Simoes. And just as a point of clarification, the current law, California law, is basically, as is the case in many states, it requires a specific number of weeks of basically butts in seats, as it's called, to qualify. So it's a curriculum, it's a curriculum-based framework that actually specifies the number of weeks that have to be served in each. And as I think all of you know, we've talked about here, there's tremendous pressure to be much more effective and efficient in the training of undergraduate medical students and to do something about the crushing burden of debt that they experience and the what is felt by many to be kind of this hasn't changed since Flexner, model for undergraduate medical education. So with that, yes, Ms. Yaroslavsky.
So I understand what the issues are in general. My concern is this going to cause us to move the University of California, Stanford, Loma Linda, our medical training programs, our schools here in California, to the 3-year program? So I would like, I understand that we're trying to figure out what the rules are in general, and if the rules are that the academic level that's been approved, that the courses have been approved, it's become an issue for their training programs here. Why is it that my concern is that this whole discussion is pushing us into a model of a 3-year medical school situation.
Dr. This would
Dr.
not.
Nation?
The language of the motion is to allow any medical school program, whether it's 3, 4, or 5 years. Many of the schools are now 5 years because they include a year of research that is approved by LCME to be accepted by the board, and therefore its graduates eligible for licensure in California.
I just want to make sure that we're not pushing our institutions to go to a shorter period of time. That was my only concern.
Hi, and I appreciate the question, but no, as was mentioned, within the state of California, within the U.S. medical school community, I think our expectation is that the 4-year curriculum, which is overseen by the LCME and subject to rigorous oversight at all of our schools, will remain the norm. Okay. We have a number of students who need 5 years for one reason or another, maybe lesser basic science preparation or additional time for a master's. We have students who do MD, PhD programs. So for these accelerated tracks, and there are roughly a dozen now in operation across the country, these are really good programs for students who are well prepared, who may be confident about their career choice. So it's particularly attractive for those students who may wish to go into primary care, for example, to have the opportunity to miss a year of school and fees. So the cost of attendance at UC now is about $50,000 to $55,000 a year. So our view is that these would be small programs, likely by any measure, but attractive. And they're not all primary care. There's a New York program, for example, that is shortened from 11 to 10 years, but would still take a year of debt and a year of school off. So allowing the LCME standard, we believe, is the appropriate standard. Our deans of our 6 schools are strongly supportive. This will allow those graduates to come back into our residency training programs and to have a path to licensure. And we're very happy to work with the board on this.
Dr. Diego.
So just so that I understand, then the core of the education continues, right? That you must be shaving off things that are kind of elective and maybe you can bypass without it because your sciences, maybe your, I don't know, like, what do we take? Biochemistry or cell biology is really strong.
All of that and then some.
Okay, and so then you're waiving that off for the few that you think that then there would be programs within the schools. Would they be additional seats? That would be even better, right? But would they be programs within the schools to say, and then you're applying special for that, and you're taking a look to see who's going to make it through that? Is that what you're saying?
So I want to be mindful of the time, but the way these work for most schools, and I won't speak on behalf of all, is you need to be admitted into the LCME accredited medical school wherever you are in the country, and certainly that applies for our own. Then there's an assessment process. Say, for example, UC Davis has a new proposed program that would look to admit a handful of students beginning this summer who are interested in primary care. So the savings is probably, it's not a 3-year curriculum, it might be 3.5, but some of the existing language around 4,000 total hours or total weeks puts this at jeopardy. And this would be for students who know at Davis that they want to go into primary care and would essentially save them, a year's time and a year's fees.
And this is I think, 12 students.
I believe, and we have Dr. Fancher here, I believe that they're looking to admit a first class of 4 this summer. So small, again, by any measure. Most of the Davis students will continue at a 4-year curriculum. Some of our prime students take 5.
Just another question. So it's not, when we're saying we're going to approve this here for licensure, we're not dropping by any means our standards for licensure, Mr. Warden, and our students here then would also be able to be licensed in other states as well?
Well, it's really that graduates of accredited medical schools across the country would have a pathway to residency training and licensure in the state of California, provided that they have graduated from an LCME accredited medical school. So this really is good for the state, in my view. It's good for the small number of students who succeed here. It's good for our graduate medical education programs who recruit from elsewhere, but it establishes and maintains a single standard.
And this really isn't just for the licensees of or the individuals in California as well. There's a program in Texas, there's one in New York. So this is going to allow those that are under the LCME approval to be able to apply for licensure here in California, which is what we're aiming for.
And the other thing I'd add is, as Dr. Levine mentioned, within UC we have seen staggering increases in fees for our students, and just mindful of how staggering that is, I think that the attention of the U.S. medical education community and those of us within UC with our private institutions are looking at appropriate ways to reduce debt loads and barriers. This is not going to be a remedy or a sea change, but where it makes sense regionally in some particular structure, I think there'll be a lot more discussion about this nationally to get it debt.
Dr. Bishop.
This is perhaps slightly off topic, but since I have this opportunity, I'm an employee of the UC system, and I must say the staggering increases in fees have not related to staggering increases of the salaries of anybody I work with. So I really think there should be some accountability.
Me too.
No, I think there should be accountability on the basis of UC when they start talking about saving money, that there should be some accountability. This is not a joke. That there's a nationwide discussion on why our university fees going up so much, and many people feel it's because of the edifices we're building to the administrators. So I think this is something that our whole system needs to look at, and I just want to, since I had this opportunity, I'm going to take that chance. So thank you very much.
And I apologize to the members of the public and the board for not introducing Dr. Nation before she spoke. She is the Associate Vice President for Health Sciences at the UC Office of the President. She completed her undergraduate studies at Davis, earning honors in political science, public policy, and Spanish. Earned her medical degree from UCSF in 1989, and her current responsibilities include leadership and coordination of health sciences academic affairs, liaison with the deans and faculty involving educational policy and program planning, and monitoring of health workforce needs. And she has been working in the area of health workforce for a long time, and representation of UC Health Sciences programs internally and externally. She's a prolific author, particularly on the subject of health workforce, and she's the lead author at the invitation of the Institute of Medicine of a national review of health professions admissions practices. So we are thrilled to have you, and I hate to, are you done? No.
We have one more person, I think, that wants to give public comment, and then you need to vote on the motion to co-sponsor.
Sorry, Catherine. We're a bit behind in our schedule today.
This will be very quick, promise. My name is Dr. Sarah Brady, and I work for Assemblywoman Susan Bonilla. And she is the chair of the Assembly Business Professions and Consumer Protection Committee. And I have a letter here that I'll leave with Jennifer, her support for this proposed legislation. And she urges you to support it and would be very interested in authoring it.
Speaker, I've already read you Dr. Nation's remarkably accomplished bona fides, and I want to remind the board why we're having this conversation today. We have been and will continue to be involved in the approval of new medical schools, and one of the issues that has come up multiple times is we've talked about building new medical schools to address the physician shortages, but where are those doctors going to go to get trained? And so I've asked Dr. Nation to come and talk with us about the state of residency training programs and how they match or don't match what we anticipate will be the need for California citizens. And this is an issue not just in California, but nationwide. you're going to go into why they're limited, and you're going to talk. Okay, great. So I'll just turn this over to Dr. Nation. Thank you so much for being here.
Okay, thank you. How's the sound? Okay? Okay. I'm going to begin this with a little bit of context in terms of state needs. California, by comparison to the rest of the country, will be part of the focus. And I know I'm the last speaker between you all, your lunch, and the end of a two-day meeting. But I want you to feel free to interrupt or to ask questions because the purpose of this is to share and exchange information. So I'll welcome questions throughout. So the big picture, and I'm just going to take one or two slides for this, is that we know whether this is national data coming from HRSA or the AAMC or state-based data or local realities that you all are familiar with, that California has existing shortages of physicians, and we will face growing shortages of doctors in the years ahead. And I'll get into a little bit about why that's true, but I think these are all forces that you'll be familiar with. The fastest growing areas of our state, the Inland Empire and the Central Valley, already have shortages and already have compelling needs, and we think those will worsen without a combination of strategies to address them. And then we know our demand for physician and access to health services is going to increase as our population ages, as more individuals become insured through the ACA and through Covered California that we're all continuing to root for, and then as growing numbers of our California doctors retire. So a few metrics. So we are the 13th fastest growing state in the nation. We're getting older. We are among the most diverse in the country in terms of race and ethnicity, and in terms of languages spoken by the people who live here. We have, I think, forever had a longstanding maldistribution of physicians, and this isn't unique to the state of California. So my hometown is Santa Barbara, and Santa Barbara has no shortage. But we have shortages all over this state. Where getting physicians to locate continues to be a challenge. A big picture, and 51 of 58 California counties, and this is a little bit dated, I think the actual number may be 53 now, have federal designations as shortage areas. California's physician workforce is also aging. According to a recent summary and state profile that I have a few statistics in other slides for, 30% of our doctors are now age 60 or older, making us the second oldest doctor community in the country behind New Mexico. So we know that there will be a wave of retirement that is coming for many docs. So the system that is intended to contribute to replenishing our workforce, and California has relied on in-migration for a long, long time, so it's not just California schools and California graduate medical education programs that kind of fit our need, but really by any measure, California has a small medical education system. And by medical education system, I mean medical students and medical residents. So we have roughly 6,500 students enrolled in our now 11 medical schools. I'll get to the list of those that I think this board knows well, but on a per capita basis, California has a statewide medical school enrollment of about 18 students per 100,000 population. That's by contrast to the state median for all U.S. medical schools, all states that have a medical school. We've got 4 or 5 states in this country that don't have medical schools, so they drop off this ranking. So among those who do, California is the 3rd lowest in the nation.
The medical school included DO school also?
Yes. Let me move to my next slide. Here you go. So our California medical schools include those that are public and those that are private. Our public medical schools are operated by the University of California, and we now have 6 schools. And just to highlight how slow the growth has been, you see San Francisco has a history that's about 100 years old. UC Los Angeles has a medical school that's 50 to 60 years old. Davis, Irvine, and San Diego began in the late 60s, early 70s at a time of growth of medical schools across the country. And Riverside is our first new medical school in the state of California in more than 40 years. And a huge fight to get there based upon the resource intensity that's required and the standards that must be achieved. And that was with a long-standing program in the basic sciences with UCLA. So it's no easy matter to open a medical school, but we are small. Our private institutions are Loma Linda, USC, and Stanford. And then to your question about the Doctor of Osteopathy degree, we have 2 in the state, Thoreau and Western University of Health Sciences. I'm going to go back. If we take to my earlier comment about being 3rd lowest in the nation in terms of total medical students, and that includes medical students enrolled in public schools, private schools, and osteopathy schools. If we look at that same AAMC data regarding medical students enrolled in public schools, California becomes last in the country. Wow. So UC, is my day job, so I'm going to include a number of facts, and we play a big role in the state because we're half of the medical schools in the country. We train roughly half of the medical residents in the state. We train roughly half of the medical residents and fellows, and they are roughly 2/3 of our entire health sciences enrollment. So in addition to our 6 schools of medicine, UC operates 11 other health sciences schools in professions like pharmacy and nursing and public health, optometry, and others. So medicine is the big portion of our enrollment. So to GME, I think everyone here knows this is the 2nd phase, and I'm no longer surprised when I'm in Sacramento about the folks who don't understand the difference or distinction between a medical student and a medical resident. So I think it's incumbent upon all of us who work in this area to chip away at the need for education about facts and how all of this works, or sometimes doesn't. But GME is the 2nd phase. So this involves individuals who've graduated from a medical school. And for my purposes, I'm going to intend this to mean graduated from an accredited medical school, which is typically 4 years, and typically for most schools in the country requires passage of 2 of the 3 national exams that are required for licensure. So those are the U.S. Medical Licensing Exams Part 1 and 2. So our residents graduate with a degree, not yet a license or specialty training, and they enter a GME program that ranges from 3 to 7 years or more to obtain their preparation to practice in a given specialty or subspecialty. So shorter period of time in primary care specialties such as internal medicine or general pediatrics or family practice, assuming those individuals don't go on to subspecialize, much longer in professions like neurosurgery. So terms, intern is a term that you still hear a lot. It's not so much used by national accreditors or training programs, but these are our first-year medical school graduates who are in a residency training program who have not yet earned a license. They're not yet eligible to sit for a license in most states, including California. So in the higher ed and GME world, we refer to them more commonly as postgraduate year 1 or PGY1 residents. Residents are everybody who is in graduate from medical school who is participating at any particular year in an accredited residency training program. The term fellows, we often hear quite a bit, and fellows is intended to refer to those who've completed a first board, such as internal medicine or pediatrics or general surgery, and who are now entering subspecialty training, say for internal medicine in an area like cardiology. So these are programs where additional skills and qualifications are necessary for board eligibility or board qualification, which is a prerequisite for medical staff privileges in most places. And then house staff is the affectionate term on campus that we use for everybody who's participating in a training program. So these are not our faculty, and these are not our medical students. International medical graduates, I won't speak too much other than to say that those are graduates, including U.S. citizens of medical schools outside of this country. If we look across the country, there are about 27% of residents in ACGME accredited programs were international medical graduates in 2011. For California, this number is about 12%. And for UC, which is half, our number is probably under 3%. So very small level of or number of international medical graduates in our UC training programs, and I think that that is truly a function of competition and demand. California graduates want to come back because they had to go to medical school elsewhere. Talented grads from other medical schools come back and enrich the training environment, but highly competitive because still small on the GME arena. And a topic that we could all devote, I think, hours to, and one of huge concern, I know, to the board and to my colleagues in higher ed and in medical education in the state and within UC, are the huge number of brand new unaccredited schools in the Caribbean operating on a for-profit basis with large numbers of California students enrolled who may have no path back, but who will nevertheless see upwards of $200,000 in debt on graduation, yet are there hoping to come back one day. So who's the boss of GME? We talked earlier with about using the LCME, who is the boss of medical schools. We said in connection with the establishment of Riverside that we needed the governor and legislature's support for funding, but the legislature and the governor can't establish a medical school, and the president of the university can't establish a medical school. The LCME is the boss of who is a medical school. The boss of who is an accredited residency training program is the prerogative for post-MD, and I'm going to set aside the osteopathic programs. There are those also. And graduates of DO programs are eligible to participate in allopathic medical education programs, but it's the ACGME that is the national entity that oversees and monitors the establishment, approval of not only institutions to sponsor these programs, but the individual requirements for accreditation of specialty-specific programs. So there are now 27 first board specialty programs. These are the big ones, as I mentioned: internal medicine, pediatrics, general surgery, anesthesiology. There's been a huge proliferation over the last decade of subspecialty programs that the ACGME recognizes following nearly every board, and roughly 100 are now recognized by the ACGME as subspecialty. There's not a specialty that doesn't have a growing number of subspecialties. So anesthesiology has followed by pain management, and family medicine has sports medicine and others. So a few of the numbers. So for California, we have 783 ACGME approved training programs in the state. 321 of those that are training about 80% of our residents, or 7,900, are in first board programs. There are another 462 training the remaining fifth of our house staff who are enrolled in subspecialty training programs. And these in California are run by 69 different institutional sponsors. So for UC, we have our 6 different institutional sponsors by campus. Our private medical schools are their own institutional sponsors. Other academic health centers, such as Cedars, are their own sponsors. Kaiser is a major sponsor of graduate medical education. We have our children's hospitals focusing on pediatrics and pediatric subspecialties. And this last bullet probably ought to say other community-based programs. But by that, what I mean is smaller programs that offer a smaller number of training programs. They're not big educators, but they play critical roles in their communities. So here's a look, a little picture. So what you see in the donut is the number, roughly 10,000 for our state. You see the distribution for the University of California that is, again, at about half. We see a teeny tiny sliver for UC Riverside, and in today's desert, I won't get the name of the paper right, but the paper for Riverside, there is an article announcing the recent accreditation of a new family medicine program for UCR. So kudos, but you see a very small number. Then that number for Riverside is intended to grow as the medical school develops and as they work with the ACGME to establish graduate medical education programs in the area. To the left, you see the types of medical school graduates who are enrolled. So these graduates distribute themselves across the circle. 8,500 graduates of MD granting medical schools, about 1,180 international medical graduates, 658, and this is 2011 data, graduates of DO schools, and a small number from Canada.
I'm sorry, why did you separate the Canadians? Do they go through a different pathway, or I'm just curious why they weren't lumped into the internationals?
Because the accreditation, the LCME accredits most Canadian schools.
Right.
Okay, all right.
It's a sister agency of LCME in Canada which accredited. So those are the only two schools considered equivalent compared to the others.
So, and because our national data source breaks some of this out by state for us, I didn't want to leave 24 out.
Right.
Okay. So here's the breakout for UC. So we're about half of the state of California total that are enrolled in UC-sponsored programs. Included in this number are a number of residents enrolled in family medicine programs with whom UC campuses have had a long-standing relationship. So those numbers are folded in, and they would appear in the primary care box. It's 42%. So not all of those family medicine residents are at UC, although UC has family medicine programs at its now 6 campuses. So the good news, the bad news is we've got challenges ahead. Some of the good news is that where an individual does residency training is the greatest predictor of where a physician will practice. So the first stat is for the country as a whole, 47% opting to return to or remain in the state where they finished their training. But California is first in the nation. So by comparison to being the lowest in the nation in terms of medical student opportunities on a per capita basis, we beat the rest of the country in terms of graduates of our residency programs across the state who opt to practice here. So investment in GME in California is a wise, in my view, investment in terms of its the predictability that graduates will remain here. So here you see the breakout, 70%, that's the number that leads the nation in terms of, and California's ranked first for in-state retention, and you see the other numbers as medical school is factored in. So financing, as I had conversations with the staff, is another hour all of its own, or another half hour all of its own. But I'll have just a few bullet points to try and give a big picture, but not the detail that's worth understanding. So that may be an opportunity for another time. Medicare, of course, is the biggest funder of graduate medical education in the country. Medicare pays for significant direct and indirect cost of educating doctors, but it is tied to a very complex formula and to caps that are that date back nearly 20 years. Again, I'm using UC data because it's mine to share. For UC, we receive roughly $100,000 in GME payments for each slot for which Medicare makes a contribution. And so for us, that's about 2,000 of our 5,000. So there's no Medicare support for 3,000. That's a function of the cap and the fact that we have positions at our affiliated hospitals that may be the beneficiaries of those Medicare dollars. Those are dollars that flow into hospitals rather than to schools. Total cost to train a resident average roughly $150,000, and I want to say that's very, very rough. So interns are far more expensive than fifth-year surgical residents who can practice more independently. This is a function of supervision. It's not a function of salaries that we pay to our house staff because we don't pay them very much. But it's a function of time. It's a function of oversight. It's a function of standing elbow to elbow in teaching and training the skills. So that 150, just take with a grain of salt. So the DGME are salaries. So a first-year resident in UC earns roughly $50,000 a year. Benefits are running higher and higher, not just for residents, but all. And some faculty time. IME costs are for what I'll call je ne sais quoi. They're the other things that are associated with teaching. It is the additional time. The pace is slower in caring for patients when you teach. It is the additional use of testing or technologies that occur in connection with teaching programs. And it's also the fact that teaching hospitals, particularly major academic medical centers like those that the University of California operates or those that Stanford or Cedars operate, take care of some of the sickest patients in the country. We're burn centers, we're transplant centers, we're trauma centers. So this is just to say that we haven't moved the dial nationally in terms of federal support in a long, long time. So again, the Medicare funded slots for UC is a bit over 2,000, but we have 5,000 medical residents. The UC slots over the Medicare cap, the reason you don't see a number 3,000 here is because these are the positions that are based at the hospitals we own and operate. So we put positions where our residents rotate at VA hospitals, at community hospitals, at county facilities, at places where we have an affiliation agreement to round out the educational program, and those hospitals are eligible to capture their own Medicare GME, up to the cap that was established decades ago. So the big challenges for medical education are the crushing, slashing of state support to our higher ed segments, and UC operates the programs, the prepared docs, but slashing of the budgets for California state universities and community colleges. That has been matched in turn by dramatic increases in fees. I mentioned earlier that the cost of attendance in medical school for one of our students is roughly $50,000 to $55,000 per year. So this is $30,000, $32,000 in total mandatory charges. The total cost of attendance means students have to pay rent, they have to pay for utilities, they have to pay for their insurance, they have to get around, and our training programs are located in high-cost cities. And so back to sort of the start, we've got growing demands in the state. We've got a disconnect between medical student and slots and graduate medical education. We have UC Riverside with just 50 students per class in its very first year and beginning to grow and develop medical education programs in the region, which are drastically, desperately needed by the individuals who live in those regions. And I'm going to really commend the founding dean at UC Riverside, who is making it his mission and priority for the medical student program and the resident programs to make a priority the admission and selection of students who want to remain in the area, and same for GME. So qualified individuals, huge demand, 3,000 applications for the first class of 50. Strong demand, but they're really focusing on the region. So we're going to be increasingly stretched, and nationally there's a growing mismatch between the number of medical school graduates in the country and the number of first-year slots that are available for those U.S. medical graduates. The Delta has been filled by international medical graduates in years past, but without the expansion of graduate medical education, we won't make progress very quickly in terms of addressing the nation's needs. And then you see I've got just 2 slides left. Some of what we have done. Over the last decade, we've increased our total medical student enrollment by about 300 to 330 students through our UC Prime initiative that is on 6 campuses focusing on the needs of medically underserved communities. Each of our medical schools has one. The area of focus varies. Davis, for example, has a focus on rural health and telemedicine. UC Irvine focuses on the Latino community. UCSF focuses on the urban underserved and homeless. Riverside, I've mentioned. Davis has the very first accelerated program within the UC system that will admit its first group of 4 this summer. And so we'll look forward again to the partnership with the board to be sure that 3 or 4 years from now, those students have a path, provided they meet all the requirements for graduation and pass all their national exams, to obtaining a license. And then on the GME front, we've had some increases in GME, but none with federal or state support. We enjoyed the opportunity to work with the medical board, and I know the bill number here, it was not 155, so that's a typo on my end, to establish a pilot program for the UCLA campus, which is really a model. Really very special program that we're considering replicating and having some internal discussion, but this is a pre-residency training program that enables the international medical graduates who are admitted to the UCLA program to participate and increase their competitive eligibility to enter a residency training program in the state. So we're very proud of that program. We hope to see more of them. I think it's a model for other schools in the country to try and take advantage of some of the talents of individuals who are here with some preparation. We are doing a lot in terms of telemedicine, and I again mentioned that Riverside is working overtime to try and establish GME in the Valley. Yes?
The IMG, do they need to pass the ECFMG before they can be in the program, right?
USMLE. These were students that were coming, these were docs that were coming in from World Health Organization, graduated programs, doctors in their own countries in Latin America and South America. They came to this country and were not able to be in a situation where they were able to be educated, and UCLA took them under their wing with doctrinations, and this board's support to make it work. And they've put, I think, 30 to 50 docs into the community clinic situation now in Los Angeles.
It's a small, and I just want to be mindful of time in the end of the day, and it looks like lunch is about over, so I know you've got a closed session, but so this is a post-graduation from medical school, pre-entry to residency training program for individuals who are by and large graduates of medical schools in Mexico, Central or South America. So these are Spanish-speaking positions. The motive, the mission, the heart and soul of this program is to increase the number of qualified, licensed Spanish-speaking doctors in this country, where we have a tremendous need. The focus is on family medicine. So some of these medical school graduates are here in this country, but without a path. So the UCLA program prepares them to enter their residency training program, places them in clinical training sites. The path is to a match in family medicine with a commitment to practice. And our family medicine programs, particularly in the Valley and those serving large numbers of Spanish-speaking students, would love to have twice as many. These are motivated, sophisticated, dedicated doctors who are looking for the path, the same standard to get into training and to remain in this state and to practice in family medicine. And then the future is, I think, involves in medical education continuing challenges with our regulators. That's just to say that the burden is there for compliance in terms of the LCME and the ACGME, increasing, I think, good emphasis on patient quality and outcomes at an earlier stage in the medical education process, preparing toward a changed world, heavy focus on institutional accountability, growing use of technologies. We're doing a lot of work across the state in terms of advancements in telehealth that don't solve the problem, but they bridge a distance. Pursuing appropriate changes that are evidence-based and change in terms of scope of practice, and then working with our stakeholders on a number of things. And this ballot initiative, shouldn't say 2014, it's not moving forward for this year, maybe next. But this is the California Healthcare Research, Prevention, and Tobacco Tax. It's 55 pages long. You'd have to search to find this provision. But if it moves to the ballot, and if it were to be approved by voters, would propose allocating $40 million to expand, to help the University of California expand and increase the number of physicians trained through GME. So we didn't really engage in the rules about how that would work, but our reason for sort of agreeing to be that entity relates to sort of our success in running quality training programs and the profound need the state has in some expansion there, but that's a long way down the road. So that, and then there are a few references for those who like numbers about how California compares to the rest of the country.
So I have a question. To get these doctors out in the community, these residents, you almost need to have more physician mentors, people that are out there in the community that will act as supervising physicians for these programs. What other advocacy groups or the CMA or anybody else have partnered with you to try to increase this number of potential sites where these people can go?
It's a good question, and it's becoming a crisis, I'll say, as our reliance on clinical preceptors increases, right? And I'll say for UC, we value the contributions of our volunteer clinical preceptors who've been long-term affiliates, whether they are site or practice-based. The pressures in terms of practice around PACE are squeezing out opportunities for students across the state. The graduates of for-profit schools are coming back now to California, having saturated the East Coast with cash to buy access. So it is an increasing challenge, because if I'm going to supervise a medical student, it's going to slow me down in my practice. And we have those very dedicated volunteer faculty who continue to teach in an inpatient or in an outpatient setting, who value this but are feeling the pressure, and we're hearing from them loud and clear in a way that we haven't ever before. And I'll say this is true for students who are in other professions. So just the pressure around placement is real. The expectations around some compensation for which there is no funding source are continuing to grow. But to your point, this is value. That's at the heart and soul of our PRIME program. Mentorship by community-based physicians, whether they're in our rural communities or serving the poor and the homeless in San Francisco. Mentorship is a big component and an area of priority for those programs.
And just to remind the board, I think your third or fourth slide from the end, the third bullet, which is what prompted this conversation, which is the 30% increase in undergraduate medical education slots over the last 10 years, and a much smaller increase in graduate medical education slots because of the cap put on the training programs in the 1997 Balanced Budget Act, and that Medicare has had neither the funds nor the will to try and change that. So the gap is growing. It is squeezing out IMGs and international medical graduates, and alternative sources of funding are going to be necessary to close that gap. So, Ms. Yaroslavsky and then Ms. Wright.
So is there any expectation or any national initiative going forward that's going to move the Medicare needle at all? And what do we have to do to try and make that happen?
Well, I see a few people smiling and looking skeptical who may want to answer the question, and then I'll add my 2 cents.
Yeah, I can answer that as part of AMPAC board and involved in AMA. It is a big initiative at AMA to really increase the GME slots. But the resistance we are getting at Congress is just unbelievable. But their answer is that it should benefit everyone, so everybody should participate, and to say Medicare should not be the only one who funds medical education. That's what the bottom line answer we are getting. But one of the solutions, though, I think many of you are asking, the cap does not apply if you never had residents. Then you have 5 years to create a cap. So the one solution is, that's what we're trying to do in Inland Empire, is work with the community hospitals to create primary care residency programs and do them in such a way that get to your maximum number within 5 years so that your Medicare cap is reached. So if you do that, and the average payment is about, if you have at least 40% Medicare, your average payment is going to be about $100,000. So you still need to subsidize a little because you got to pay the faculty too, not just the residents. But it becomes very close to break even with a little more expense. But what the community hospitals get is they have 24/7 docs in hospital compared to just an ER doc sitting in the ER for a 250 to 300 bed hospital, which is scares me to death. I mean, I come from a teaching place, but it really scares me having one doctor. So I'm working on Inland Empire, and about 3 community hospitals are very interested, and we are working together as a consortium to really create these things. So that's one way to go around the cap. The other way is, I think we need state to help us, and in the end we need to make sure that health plans pay for the medical education. Unfortunately, we tried to carry that bill last year. It didn't get to go too far. We means, I think CMA tried.
And we work with the California Medical Association on a number of issues. We're not always in agreement with all, but on those areas around workforce education, medical school debt, GME, and it was actually CMA who brought the ballot initiative language to us. And we were a bit reluctant, I'll say, in Oakland to say that UC should be, maybe the boss of it. But there wasn't an easy alternative in terms of another institution with a record of success in running these programs, and there wasn't a lot of appetite for establishing this, and it's not passed, and it's not established, and it's not funded. But if it were, would it belong in a state agency? We didn't think so. If we got there, we would be looking across the state in terms of need. But the little exception that allows teaching hospitals that may be new to ramp up in 5 years, it's a little window, but it's not a public policy or a workforce solution, but it is an opportunity. It puts the onus on new hospitals to try and do that quickly, but it won't get to all the needs the state has.
And do I have any other important questions from the board? Since
Madam Chair, one other comment is that if you are in rural area, there are HRSA grants you can apply for to start the program. Remember, CMS reimburses you after you take the costs on, but HRSA grants actually help you to start the program, but it's for rural primary care programs, which is part of ACA. So I think that's another one you can take it back. And we are working on a couple rural areas to start family practice and internal medicine programs to get that going.
Dr. Bishop.
I always seem to have the unpopular statement, but this process of this crisis that we see now is not something that was unknown for years, yet somehow now it's a crisis. And in the Me Too rush of everybody that wants to show how wonderful they're helping out, I'm concerned that we're missing the quality part of things. And you touted the program you have, bringing physicians who are trained south of the border up. And I work at UC San Diego, and I see some of the disasters that cross the border after they've been treated by these well-trained physicians south of the border. So I just want to make sure that we're keeping our quality up. That's what citizens demand. That's what they require. And I'm just worried about this mad rush from the legislature and everybody else to have a Me Too voice in this, because I just think we need to be very careful. That's just a statement I'd like to make.
Well, I want to echo your concern. So I will say that for our UC programs, we have very high graduation rates, very little attrition, very high success rates in terms of passage of exams, and very high standards for entry. The UCLA program is a very teeny tiny program for just a small number of talented individuals who get put through all of their paces in terms of matching into a family medicine program in this state. Generally, where the physician staff know that individual from some preceptorship, they must continue to graduate successfully. They've got to pass their specialty boards. They've got to successfully meet the requirements for licensure here, and it's putting out maybe 15 graduates a year.
I second that. I think if we don't do something, the legislature had something a few years ago where they were going to allow doctors who are trained elsewhere without going through any training to practice in low-income neighborhoods. I thought that was the biggest disaster you can ever ask for. Just because you're poor, you're going to be taken care of by these ill-trained people. So I think we need to come up with should not lower the standard of care, but we need to come up with how we can get doctors to poorer neighborhoods.
I just wanted to add, because the whole idea was to train them here to begin with. So, and we all know that most of our training and our learning really happens in, graduate medical education, right? We talked about the medical school. So my worry is, just as you guys are putting out these rural programs and everything where there hasn't been training, to Dr. Bishop's point, is the quality of training the same? Because, you don't have the experts there unless you have like the strong support from the UCs and the Stanfords of the world to support those rural programs, right?
Well, to maybe correct a misunderstanding, UC operates for medical students one rural prime program, where students have to get into the Davis School of Medicine to begin with. They do their basic sciences side by side with every other student who is admitted there. What they get then, most of our prime programs, because we believe the poorest and sickest people in this state need more care, better care, rather than lesser care. These were initially structured as 5-year MD with master's programs. We've gotten very flexible on that 5th year because of our worry around debt. But these are really kind of the cream of the crop students who come from rural communities, so that there's a focus on recruitment. There are volunteer faculty preceptors. Our faculty on site are the champions of these students. They are their mentors. And then the placement in terms of the 3rd and 4th years are in rural locations for the rural prime program. So same kind of idea, but not rurally focused for our urban prime program at San Francisco. Closely overseen, subject to the same standards. So absolutely agree. There's no slipping of the quality bar, at least from our point of view, in running these educational programs.
I have a question. I'm just curious, a couple months ago I went to a meeting and the interested party was one of the people of color medical societies. And so I see that you reference Inland Empire and Central Valley, but what are you doing to sort of, one of their concerns was there aren't enough doctors per capita for people in high density, low income areas. So what is the sort of projection and how are you helping to sort of buffer some of that for people that live in those areas?
Well, that's a big question, and I'm seeing the look of folks here about attempting to be brief, but I do appreciate the question. So,
do you want me to narrow the scope of the question?
No, I think that it is exactly the focus of our urban underserved prime program. Okay. Again, these programs are small, but to focus on the needs of the poor, the homeless, the drug addicted who are in urban locations, but where docs may be concentrated in the suburbs, may not offer a path to care. Mm-hmm. And because our UC campuses sit in urban areas, our medical students and our residents rotate through sites. They rotate through county facilities, they rotate through VA facilities, they rotate through student clinics. That do serve a large degree of underserved and or unfunded and or uninsured individuals. Unfortunately, we still have the salary incentive for specialty selection. We still have the personal prerogative of individual docs about where they go to practice and where they want to raise their family and where they want their kids to go to school. So it's a long-standing problem for the country.
Is there a cultural competency portion to your training?
There's a cultural competency element for all medical school programs. That's a requirement of the LCME, but it's also a reality based upon the population we serve. Patients who are served by UC health facilities and who UC residents and medical students see speak upwards of 200 different languages. And our students are actually far more linguistically variable than our faculty. But yeah, there's a cultural element, and it gets adapted locally based upon population, but it's a mandatory requirement.
Thank you.
Any questions or comments from members of the public? Seeing none, I want to thank you so much, Dr. Nation, and apologize for squeezing you between bites. I know you could go on for hours, but appreciate your coming.
I was trying not to.
We have one other agenda item before we adjourn the open part of our meeting, and that is any agenda items from board members for the May meeting. Any agenda items from members of the public? Seeing none, if anyone thinks of anything, please communicate with Ms. Kirkmeyer in the next month or so we can put the agenda together. And can I have a motion to adjourn?
So moved.
Second.
All in favor?
Aye.
Opposed? So we will adjourn and we will reconvene in 5 minutes for a closed session of the board. So we are back in open session now. It is 4:15, and I want to share with the public that we have concluded our interviews for the permanent position of Executive Director of the Medical Board, and the board has offered the position of Executive Director to Ms. Kimberly Kirkmeyer, who's been serving as the interim executive director since July of 2013, and that is, of course, as per SB 304, that is pending the approval of the Director of the Department of Consumer Affairs, Ms. Denise Brown. So I want to thank everyone who hung around and waited with us, and I want to thank all the candidates for their patience with our process. It was a pretty rigorous process, and we feel, the board members feel really good about it, and we look forward to working with you for at least 5 years. Yes. And with that, our business is completed for the day, and we'll see you all in May.
Motion to adjourn.
No, we don't.
We don't for those?
We don't.
Feels good.
It kind of, okay. Ta-ta for now.
Ta-ta for now, right? Apparently, the lawyers tell us we don't need a motion to adjourn.